Versus Brad Compher, CR 2014-12727. Janice Price and Brian Trammell for the state, Scott Andrew, Gary Proctor, and Riley Fry for the defendant and the defendant present. We are outside the presence of the jury. Mr. Trammell, you indicated the state had an issue to take up this morning. Go ahead.
Your Honor, the state's going to ask the court to take judicial notice of the name change of Mr. Compher from 2008. The state does have the documents, the petition, the order, the publishing. I can provide that to the court. I believe the defense has those documents as well. Under Idaho Rule of Evidence 201, the state believes that's appropriate. Specifically, it says the court may judicially notice a fact that is not subject to reasonable dispute because it is either one, generally known within the trial court's territorial jurisdiction, or two, can be accurately and readily determined from sources whose accuracy cannot reasonably question. And I would note that this is from the 6th Judicial District in the County of Bannock where this name change took place. And also at the timing, the court may take judicial notice at any stage of the proceeding. And if I might approach the court with the documents.
Yes, you may.
Thank you.
Or can hand them to.
So have defendants reviewed the documents? I presume that's the case, but I want to make sure.
And Your Honor, if I might add, even in a criminal case, the court can make that a finding of judicial notice. However, the jury must be instructed that it may or may not accept the notice of fact as conclusive. Which? Oh, yeah.
All right. What's the defendant's response?
Your Honor, we would object to the taking of...
Mr. Andrew, can you pull that microphone closer to you, please?
Your Honor, we object to the taking of judicial notice. This is a matter that could have and should have been certified by the clerk. As far as it being accurate and readily determined from sources whose accuracy cannot reasonably be questioned, and provided any information as to the source of that, the accuracy, and how it's readily determined from sources whose accuracy cannot reasonably be questioned. They've simply recited the rule.
They simply what?
So they simply recited the rule. They didn't provide any basis for the court to make that determination. Under subsection C, they must identify the specific documents or items so noticed, which they've provided. So they haven't specified, but they have handed the court the exhibit. I'm not going to challenge it. They're not. If they've handed the court what they want the court to take judicial notice of, I'm not going to complain about that piece of it. But I think as far as taking judicial notice, I think it's an item that they haven't established that it comes from a source, that the copy they have comes from a source whose accuracy can be accurately and readily determined. So I'm objecting under B2.
All right, well, I've been handed, and I have in my hand right now, Exhibit 3, which, for the record, has the petition for name change, the matter of Ralph Roy Compher, Bennett County KCVO 84639, notice of hearing on name change, proof of publication, an order for name change signed by the court January 6, 2008. And then the last page, an incomplete notice of hearing on name change. No, Mr. Andrew, I'm trying to understand your objection. Are you stating that because the order of the name change in Exhibit 3 is not a certified copy, it's not reliable?
I'm saying they haven't provided any information that it is. They've simply recited the rule.
Okay, is there anything under Rule of Evidence 201 that requires a certified copy to make it a reliable source? Help me understand your objection, please.
I believe that is the way to show that it's a reliable source. It also, and I should have made this part of my objection as well, which is Rule 901, which is talks about authentication, identifying evidence, and 902.
Self-authenticating documents. Okay.
Correct. One, they have to provide sufficient evidence to show that it is what they purport it to be. And then under 1002, providing an original writing, recording, or photograph is required to prove its contents unless these rules or statutes provide otherwise. I think they're trying to admit a copy. They should have provided the original. I understand that they're not going to be able to provide, actually they may be able to provide an original, but certainly a certified copy of the original from the clerk's office. So my objection is under 201, 902, and 1002.
All right. Mr. Trammell, any response?
Yeah, thank you, Your Honor. We're not saying that this is self-authenticating. We're going through the certification process, and I don't have the exhibit right in front of me because I handed it to the court, and I believe that there was a signature or a stamp from a Diane Kano on there as well. But the rule for the court to take an adjudicative fact is if the court is supplied with necessary information. The court has been supplied with the necessary information to make that determination. Of note, if the court is supplied with that necessary information and not to convolute it into the self-authentication category, which I believe the defense is trying to do at this point, the court has to take judicial notice of it once a party requests the court to do so. But the state feels that the court can take judicial notice because its accuracy can readily be determined from sources whose accuracy its accuracy can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned, such as looking up the case in the court portal or going down to the clerk's office since it happened here. We provided a case number, we provided the order, the petition, the publishing. The court has enough information to take judicial notice. Thank you.
So that I understand the state's position too, you're just asking the court to take judicial notice that Brad Scott Compher's original name was Ralph Roy Compher, he was changed to his current name. You're not asking the court to have Exhibit 3 admitted?
Well, we are going to want Exhibit 3 to be admitted, Your Honor.
Okay. Well, why don't we do that first before we do the judicial notice, okay? It is within the court's discretion to take judicial notice. So that's kind of where I'm at this point. I think the cart's before the horse on the issue.
All right.
If you're going to want this admitted as an exhibit, then let's do that.
Well, Your Honor, then at this time, I would just ask the court to take judicial notice.
Okay. All right. Well, any further argument, Mr. Andrew?
I'm going to stand, as far as the objection, I'm going to stand on that. If the court takes judicial notice, I think we need to talk about what the court's taking judicial notice of and how we're going to deal with that. There's information in the exhibit that I think is should be excluded as under 401, 402, and 403. And then under subsection F, it says the court must instruct the jury that it may or may not accept the noticed fact as conclusive. So we have to define what fact the court is taking judicial notice of.
Your Honor, the state would be fine if the court just took judicial notice of the fact that he changed his name in 2008 from Ralph Roy Compher to Brad Scott Compher. And the reason for it, I believe that was stated, is that he didn't feel like a Ralph. And any other information we're fine keeping out.
Say that again, Mr. Trammell.
The state at this time, hearing the defense's objection, would be fine with just the court taking notice that he did change his name in 2008 from Ralph Roy Compher to Brad Scott Compher. And the reason for that name change, he stated, was that he didn't feel like a Ralph. I believe that's what he put in the petition.
Well, why would we need that if we've got the order granting his petition to change his name from Ralph Roy Compher to Brad Scott Compher? Why do we need to know the reason why he changed his name? Wouldn't it just be sufficient to ask the court to take judicial notice of the fact that he's changed his name from Ralph Roy Compher to Brad Scott Compher?
Yeah, I understand, Your Honor.
And Your Honor, if the court's going to allow it, I would prefer that language to be in there as an explanation for why he changed it.
Okay. Well, in there, under the rule, if I do take judicial notice, I need to instruct the jury. So we'd all need to work on a jury instruction to that effect. So, all right. Well, I understand the defendant's objection. They've objected to whether, under Rule of Evidence 201, whether Mr. Compher's name change can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. We don't have an original order, and it's not a self-authenticating document, although under 902, Rule of Evidence 902, Paren 2, we've got Judge Box's signature on the order, but it's not certified. But I have no evidence from the defendant showing that Judge Box's signature granting Mr. Compher's petition to change his name is inaccurate or otherwise could not be accurately and readily determined from that order. So I understand the defendant's position under Rule of Evidence 201, 902, and 1002. The Rule of Evidence 1003 also allows for the admissibility of a duplicate to the same extent as an original, unless a genuine question is raised about the original's authenticity or the circumstances make it unfair to admit the duplicate. So, again, I don't have any evidence to establish from the defense that the order granting the petition of Mr. Compher's request to change his name is not the order granting that request. So I'll overrule the defendant's objections, take judicial notice of Mr. Compher's name from Ralph Roy Compher to Brad Scott Compher. And Mr. Andrew, as you stated, if you want language in a prospective order to the jury or criminal instruction to the jury regarding that, I'll look at that and we'll go from there.
And Your Honor, would that also include the date of the name change? And the court taking notice?
If
The
that's
state
what
believes that's important.
All right, I can take judicial notice that the order was entered on January 6, 2008. Ralph Roy Compher changed his name to Brad Scott Compher. So again, provide me with a proposed jury instruction regarding that, and I'll look at that, and we can finalize that when we do our jury instruction conference. Mr. Trammell, you want Exhibit 3 back?
Yes, Your Honor, thank you. And Your Honor, would it be the court's preference to not let the jury know about that judicially noticed fact until we get that instruction in? Or?
Correct.
Okay.
Under the rule, I have to instruct the jury, so I want both parties to be at least on the same page as far as the proposed instruction, and we can take that up during the instruction conference.
Okay. And so that brings up one additional item in the interrogation of Mr. Compher that the state's planning on putting on this morning. I know the defense has had a chance to review. They do discuss the name change in that interrogation. I don't know if that brings up an issue. I don't think it does, but I just want to address that right now.
All right, Mr. Andrew, you're shaking your head. Was there an issue?
Just, Your Honor, I'm aware of the interview. I'm just puzzled by this whole exercise, given what's in there. That's it. It was just a comment that I was making to my co-counsel. It's
Okay.
Not anything for you to consider.
Okay, well, I wanted to make sure that there's, so is there, I guess that's what Mr. Trammell's asking, Mr. Andrew, is there going to be an issue regarding that stated Mr. Compher's name change being questioned or part of his interview?
It was a statement made by the defendant, and I understand the relevance because of the different names on the print card. So I could object, but it would be frivolous. So.
All right, so as far as that video then, are there any objections to that at this time?
No, Your Honor. As I understand it, this is the video that was worked on earlier by Mr. Bainey, where some of the objections I had were redacted. So I had listened to it, verified that the items were muted, and then gave that back to Mr. Trammell, and I've assumed that's the same one Mr. Trammell's offering today.
Okay, well, I don't want to assume anything.
Okay.
Has that video been redacted as requested by the defense, Mr. Trammell?
Yes, Your Honor.
Okay, so again, I don't want the marshals to have to be monitoring what the jury's listening to or not listening to. So again, what you have, whatever the exhibit is, the video, that's in form, if it's admitted, to go to the jury without somebody having to press a mute button.
Yes, Your Honor.
Yes.
All right. Very well. Thank you for working on that and doing that. And any other exhibits then
No, Your Honor.
that need to be redacted or otherwise modified that we wouldn't have to or have to take a recess for?
Not to the state's knowledge.
No, I do want to talk about Mr. Spillett before we start this morning.
Okay.
So, Your Honor, Mr. Spillett was served. He called my office this morning about when he would be testifying. My instructions to the person that took the phone call was to let him know that he would be called at 9 o'clock tomorrow and to get a phone number. The reason I got a phone number is because it's my understanding the court has already appointed an attorney to represent him because of the Fifth Amendment issue. I don't know who that is, but
It's Bob Eldridge, actually.
okay. So it would be a matter of Bob having enough time to speak with him, go through the evidence. So one of the things I've done is I made copies of Mr. Spillett's one interview. One doesn't have any sound, but it's 7 hours of interview. All the supplement police reports regarding him, all the evidence, et cetera, so that it's kind of packaged up for Mr. Eldridge to look at without having to review the entire case. That's available for him. I don't know what we want to do in terms of reaching out to Mr. Eldridge so he can find out sooner than later, because if Mr. Spillett's going to plead the Fifth, that puts us in a totally different setting, because I'm going to have to ask for him to be an unavailable witness. And then it's a matter of how his statements are coming in. So my proposal at this point, if he is going to plead the Fifth Amendment, would be to call Detective Daniels, who was engaged in in 3 of the interviews with him, but to play, I think it's Exhibit BBB, which is the first of 3 of the recordings.
Said BBBB as in boy?
Correct. And to do that, Your Honor, because primarily the information I'm trying to elicit comes from BBB. There are other significant statements he made, but in terms of listening to the actual statements he made, I think it's important that the jury be able to do that, and those are the important ones. If the state wants to play the whole recording or play all of it, they certainly can do that to add context or whatever, or ask Officer Daniels or Brennan or Collins to fill in the gaps with any other statements that he made. But that's the concern I have right now, is that Mr. Spillett's going to plead the Fifth. I'm going to have to ask that he be declared an unavailable witness, and I think the recordings are going to meet the criteria for admissibility of the prior statement where he's unavailable. So that's kind of my plan. I wanted to let everybody know that that's on my brain, because that's a likelihood for tomorrow. If he's called as a witness, then obviously I'm going to be asking him direct questions. As far as the offer of proof, I'm assuming we're going to start in the morning, and then I'm going to have to call him, and then the court's going to assess whether or not that's sufficient. So.
Right, that's what has to happen. You need to make your offer of proof. I do the assessment, and then we see where it goes from there. So as far as the video, that's 7 hours in total?
If we were to play the entire interview, it had to be placed on 3 different discs, and each one I think is about 2 hours and 30 minutes. And he gets through most of the 3rd one before they discontinue the interview. I think there's like a half an hour, 40 minutes where he's just in the interview room by himself, so there's no commentary after that. My thinking about playing all of it is that at some point it's just repetitive and duplicative. They're asking him the same things, they're exploring the same things, he's giving the same answers, so it's a little bit of a 403 issue where it's just duplicative. So I think everything I want focused on with him is in interview BBB, and then there are other little things that I might bring up, but I think I can do that through Detective Daniels faster. So it's a matter of time management, but I really do want them to watch the interview if he's not available.
All right, so that I understand, Exhibit B as in boy, that's not the 7-hour, the 3-disc 7-hour interview?
That would be, I think, 2 hours and 30 minutes. CCC is part 2, disc 2 of the interview. That's 2 hours and 30 minutes. And then there's a disc 3, which is DDD, as in dog. That one is also 2 hours and 30 minutes roughly, but the last 30 minutes or so, it's just him walking around in the interview room. So I'm only proposing to play the first one. So it would be roughly 2.5 hours of an interview.
All right. All right, State, have any responses regarding that?
Well, Your Honor, it's difficult to take a position at this point. I mean, we'd have to take a look at the evidence as it comes in. If Mr. Andrew is attempting to elicit this under a statement against interest, there has to be the corroborating indications of reliability, and I just don't know that there's been a showing yet. So I think we have to go through the motions. I'd ask that be done, as Mr. Andrew has indicated, outside the presence of the jury. And we can make a determination as to whether they can get over that hearsay hurdle and whether it gets over the relevancy hurdle as well.
Okay. Well, yeah, I realize there's some moving parts to this right now, understanding if we don't know whether Mr. Spillett will assert his Fifth Amendment privilege or not, and if he does, then we've got an 804 issue to get around, and then determine whether the offer of proof is such that I let it come in or not, at least to the jury. So, okay. All right. Anything else we need a heads up on, counsel?
No, Your Honor.
No, Your Honor.
Okay. Parties are ready to proceed?
Yes.
Yes, Your Honor.
All right, Mr. Reiner, let's bring the jury in. Okay.
All rise.
Please be seated. All right, good morning, ladies and gentlemen of the jury. Welcome back. All members of the jury have returned from the evening recess and are seated in the jury box. The parties waive roll call of the jury.
Yes, Your Honor.
Yes, Your Honor.
Very well. Mr. Trammell, your next witness.
Thank you, Your Honor. The state calls Anthony Bush.
All right, sir, please retake the witness stand. All right, Officer Bush, you understand you're still under oath?
Yes, Your Honor.
Thank you. Mr. Trammell, you may inquire.
Thank you, Your Honor. Mr. Bush, will you please, again, let the jury know what your role was with the Pocatello Police Department? Let's start in 2004, in September of 2004.
I was a detective at that time, assigned to the detective division.
Thank you. Your Honor, at this time I would ask Mr. Bush be handed State's proposed exhibit number 40.
Do I have permission to set up the Elmo?
Yes, you do.
Your Honor, the record can reflect the defense was shown the proposed exhibit just now.
Is that correct, Mr. Andrew?
Yes.
All right.
Well, for Pete's sakes. There we go.
Thank you. Mr. Bush, you've been handed what's which is state's proposed exhibit number 40. Will you please look at that?
Yes, sir.
Sir, make sure
Without
you don't
putting
have
it
it under
under
the
the
Elmo, please.
Do not put it in there.
Correct.
All right. Are you familiar with that picture?
I am.
What is it?
It's a photograph taken from the crime scene of the victim's body.
All right. And do you remember when that photograph was taken?
I believe September 28th, 2004.
All right. And do you know who took that photograph?
Detective Sellers with State Police.
Were you there when he took that photograph?
I was following him taking duplicates with the digital camera.
All right. Is that a fair and accurate picture of what you saw on that day?
Yes, sir, it is.
All right. Your Honor, at this time, the state would ask that state's proposed exhibit number 40 be admitted into evidence.
Mr. Andrew?
No objection, Your Honor.
All right. State's Exhibit 40 shall be admitted.
All right. Your Honor, at this time, the state would ask that state's exhibit 40 be published to the jury via the Elmo.
All right. Permission granted, however, I just want to notify family members that this photograph and the jury, the photograph is graphic. Permission granted to publish.
Yes. And Mr. Bush, can you please describe to the jury what they are looking at?
This would be the victim's body, naked, laying on the bed. That'd be the right hand, and then the blood that's smeared down.
Thank you. You can
Move it?
remove it, yes.
Thank you.
Your Honor, at this time, the state would ask that the witness be handed state's proposed exhibit number 41. And Your Honor, I would ask that the record reflect that the defense has been shown the proposed exhibit.
It shall. Witness has Exhibit 41.
All right. Mr. Bush, will you please look at the state's proposed exhibit number 41? All right. And what is it?
It's again another picture of the victim, a little bit higher up on the body aspect, showing more of the back and the right arm.
And are you familiar with this picture?
I am.
Were you there when this picture was taken?
I was.
And who took the picture?
Detective Sellers with the State Police.
Okay. So that picture you're looking at now, is that a fair and accurate representation of what you remember that you saw at the time?
Yes, sir, it is.
All right. Your Honor, at this time the state would move to admit state's proposed exhibit number 41 into evidence.
Your Honor, I'm going to object under 403. It's duplicative.
All right. Objections noted. It's overruled. Exhibit 41 shall be admitted.
Thank you, Your Honor. At this time, the state would ask that state's exhibit 41 be published to the jury via the Elmo.
All right. Permission granted. Again, warn the jury and family members the exhibit is graphic.
Yes. Mr. Bush, again, would you please explain to the jury what they are looking at?
This again is the victim's body. That's going to be the right arm. She's lying face down, and this is a higher aspect up. Instead of the other picture at the wrist down, this is from the wrist up.
And was this taken at the scene?
It was.
Okay. Thank you. We can remove it. Okay, Mr. Bush, I want to now direct your attention to February 16th, 2011. Were you still employed with the Pocatello Police Department at that time?
I was.
What was your position?
I was still detective.
All right. And what was your role on this case at that time?
I was assigned with, I believe, Detective Collins as lead at that point.
And on that day, did you make contact with a person by the name of Robert Spillett?
I did.
Okay. Was Detective Collins with you?
He was.
All right. During that time, did you gather 2 buccal swab samples from Mr. Spillett?
I did, yes.
Where did those swabs come from?
Mr. Spillett, his cheek swabs.
All right. Did he do so voluntarily?
Yes, in fact, we allowed him to swab himself and then hand us the swabs.
And were those swabs placed into evidence?
They were.
And who placed them into evidence?
I did.
Okay. Mr. Bush, now I want to direct your attention to June 15th, 2011. Were you still employed with the Pocatello Police Department at that time?
I was.
As a detective?
I was.
Right, at that time, did you come in contact with a person by the name of Brad Compher?
I did.
What was the purpose of your contact?
An interview.
Okay. And where did that interview take place?
At the Pocatello Police Department.
And did he come down voluntarily?
Yes, he did. He drove his own vehicle.
What training do you have in interrogation? Or what training did you have in interrogation at that time, June 15, 2011, Mr. Bush?
Several different certifications. Beginner and advanced interview and interrogation, Reed and Associates, Wicklander and Zawalski. I've been to both the schools. Detecting deception school, body language school. There were several. I can't remember the exact number, but.
And what type of interrogation tactics do you use in interrogations?
I choose to use the soft attack rather than, what you see on TV, people getting in their face yelling. That doesn't get you anywhere. More of a get them comfortable, read their body language, see when you're asking a question if they're going to close off. If okay, now I know there's something there, take notes. And generally, we'll have another detective taking notes and one doing the talking. And then we'll confer and go, okay, here's some areas we need to go back to, and then just keep talking to them. So it's rather a passive rather than an aggressive technique.
So on that day, you met with Brad Compher?
Yes.
All right.
Yes, sir.
Was Detective Collins with you in that
Yes,
interrogation room? Yes. So the person you met with on that day, do you see that person in the courtroom?
Yes, sir, I do.
All right. Can you please point to them and describe an article of clothing that they are wearing?
At the defendant's table, wearing a plaid red, gray, and white shirt, I guess you'd call it.
Your Honor, may the record reflect the witnesses identify the defendant?
It shall.
Your Honor, this time the state would request that state's proposed exhibit number 36 be handed to the witness.
You said 36?
36, yes, Your Honor. And of note is, it is a disc in a case.
All right, witness has exhibit 36.
Thank you, Your Honor. Mr. Bush, you've been handed state's proposed exhibit number 36. Do you recognize that?
I do.
All right. What is it?
It is a copy of the interview of Mr. Compher that Detective Collins and I performed.
Okay. So the original interview was about an hour and a half. Is that correct?
That's correct.
All right. So this copy of the interview, it's shorter, correct?
Correct.
All right. And the reason for that is there would be irrelevant information, and it was just redacted to put in the relevant information, correct?
Correct.
Is there, with the audio from the copy that you listened to on there, is there an issue with the audio that you noticed?
Yes, there seems to be a problem with it cutting out for 3 or 4 seconds every so often.
Okay. All right, thank you. So when you met with the defendant in June of 2011 for this interview, was it recorded?
It was.
All right. And what you have in front of you, is that a fair and accurate representation?
It is.
All right. Your Honor, the state would request at this time that state's proposed exhibit number 36 be admitted into evidence. Of note, we have provided the defense a copy of the original video and the redacted video.
Mr. Andrew?
I don't have an objection to the redacted video coming in.
All right. Very well. Exhibit 36 shall be admitted.
And Your Honor, the state would request that we publish it to the jury right now on the television so they can watch it.
All right. Before we do, counsel, will you stipulate to waive reporting of the video or the audio? Or
Yes,
both?
Your Honor, from the state.
Yes.
All right. Permission granted to publish Exhibit 36.
Now we're going to bring it here.
I think that's be turned off.
Oh, yeah. Turn it off. Yeah. Okay, and a couple more questions for you, Mr. Bush. One, what was the interview about with Mr. Compher?
It was about the homicide of Nori Jones.
Okay. And is there a lag in the interview with the video compared to the audio that you noticed?
Yeah, it seems to be off.
Okay.
So the screen is switched to Zoom. Do we have that switched to Zoom? Do we know? Does not have a code up there.
Which code?
There's a code that usually pops up on the right side.
Your Honor, I know normally I'm being told there's a code up there to log on, but it's not popping up right now.
Can I see Jan Compher?
Okay.
Is Jan here? She is. It's a message. No, it's just getting switched.
She on her way.
Somebody coming to fix.
All right. Help is on the way. Thank you.
Error code. What is it again? No, it's saying it's not the right key. Is it the same one? Well, you see, it's Brian. I just haven't seen you today, Jen.
Yes, sir.
Your Honor, the state would request a quick recess. We thought it was all set up, and it appears that once the Elmo was plugged in, things changed.
We'll take a recess here to get this issue sorted out. Again, I instruct you not discuss this case amongst yourselves nor with anybody else, nor to form an opinion as to the merits of the case until after it has been submitted to you for determination.
All right.
Present. So the issue's been resolved.
Let's make sure.
Do you want to request play first?
As I said, let's make sure.
Right, we are on the record, folks, so Mr. Andrew, would you take a seat, please? Mr. Andrew, take a seat. All right, I'm going to say this one last time. It would behoove all of you to make sure that the technology is functioning before we start court, okay? Thank you. Are we ready to go?
I believe so, yes.
Yes, Your Honor.
And do you want to play it so that we're sure?
Is there audio? Is the volume up on that?
We have the volume up on the television.
It keeps muting. Every time I mute it, it mutes it. See? Look at your desktop and see the places. Well, let's see how you pray. Get logged in soon just to see.
Stop sharing for a minute.
Brian.
And Your Honor, I know when we listened to it this morning, the audio was working.
Did you listen to it in here?
No, Your Honor.
Okay. Do we need somebody from court services then to come up and address this?
Yes, Your Honor.
All right.
It's Mark still got no. But go ahead and first. And let's just try it. So log it first. Get into Zoom. No, he's not over here soon.
All right. We'll be in recess.
All rise for the court.
Go ahead and be seated, folks. You're back on the record. Mr. Compher and his counsel are present, state counsel present. All right, the technical issue's been resolved and the video is queued up and ready to go.
Yes, Your Honor.
Yes, Your Honor, we were listening to it.
Okay, all right. Anything else, counsel, before we bring the jury back in?
No, Your Honor.
And this is playing off the disc, not off your laptop.
Yes, this is being played off the disc, not on my laptop.
I know that was a discussion. My concern would have been we need to make sure that what the jury's listening to and watching is the disc, not some other file.
Understood, okay. All right, good, I'm glad that's cleared up. And again, we've got our computer services folks here early in the morning, so just moving forward, please contact them to make sure. I know assumptions are made that it's going to work, but until you come in here and actually do it, you won't know. So, all right, thank you, everybody. Mr. Reiner, bring the jury in.
All rise for the jury.
Please be seated. Right, the members of the jury have returned from the recess and are seated in the jury box. And ladies and gentlemen of the jury, I appreciate your patience. Sometimes we've got technical issues that we've got to get experts up here to help us with. So, I want to make you know or let you know that we appreciate your patience. All right, well, counsel waive roll call of the jury.
Yes, Your Honor.
Yes, Your Honor.
All right, Mr. Trammell, you may proceed.
Thank you, Your Honor. May I publish the exhibit to the jury at this time?
Yes, you may. And members of the jury, Mr. Trammell, can you pause it for a moment? I just want to make sure, members of the jury, can you see the video from where you're seated? Everybody's saying yes. Thank you. Go ahead, Mr. Trammell.
Thank you, Your Honor.
That extra seat there, I'm sorry about that. Well, first of all, we appreciate you coming in. It's one of those things when you get a case like this, you have to talk to everybody. And there are lots and lots of names of people that we're going through. So you're not the only person that we're talking to, okay? Appreciate you coming in. You know we're free to leave at any time, That's just kind of how we roll, okay? So it's all good that way. First off, in doing when we go to talk to somebody or whatever, we do kind of like a background investigation a little bit to find out a little bit. And you have like two different names, Ralph or Brad. It's legally Brad now, but it used to be Ralph, or what do we call you? I guess I'm asking.
My dad's name's Ralph, and
okay.
I was a Ralph for a long time, and I just got made fun of a lot.
Okay.
So I changed my name.
Okay. So legally you're Brad now.
Right.
So you're Brad. Okay. Cool. All right. Well, let's start with probably, 7 years ago or so. So it's been a while. Like we said before, we have a matrix that we put people's names in. The computer will tie this person to that person to that person to this person, like an associate. So you may have known somebody who knew somebody who knew somebody. That's kind of what we're getting at as far as that goes. Now, I remember I think I showed you a picture of a house. And do you remember me? Do you remember that, or you don't remember ever being at that house?
I've never been at that house, ever.
Ever? Okay. And you're positive on that? 100% positive? Okay. Well, it's mostly what we're concerned about is what you did when you moved to Pocatello.
Right after I went to Pocatello, I had my GED, so I enrolled to college here. And I was going to go for a business major. Ended up doing a bunch of classes I didn't need to do.
Okay.
And then the math got a little hard for me, so I wasn't able to continue.
Okay.
And during that time, I worked at Red Lion as a dishwasher for like 6-7 months.
Okay.
And then I think in 2005, I got my Social Security.
Okay.
For disability and Social Security. I've been kind of shuffling. I haven't really done any jobs other than Red Lion or working for Intelligent Employment Solutions.
Okay. Did you ever go down to the job service to apply for jobs there at all?
I've gone to job for service before.
Okay. During that,
to look at jobs.
To look at jobs.
There, though.
Okay. Did anybody ever help you out while you were there? Or did you just look on the wall, or how did you? What did you do
on a computer?
Okay.
Basically.
And then go through the computer.
Yeah, because they're like down job service. So.
Okay. Yeah. They're hard to come by, haven't they? So, okay. Now, you talked about how you just kind of went to college a little bit, and then the math got hard to get out of that. And then
I went to college for about a year and a half, 2 years.
So what period of time would that have been? 2001, 2002,
Something like that.
Now, at that time, were you under Ralph or Brad? When did you change your name? I guess
2 years ago.
Okay, so a couple of years ago you changed it. Okay.
Maybe 2 years ago.
Okay, all right. So the next question, I guess, will get something about it on the news or something, but
Well, yeah, there's a...
Nori Jones is. Have you ever heard of her before? I mean, you mentioned to us when we talked to you first.
I don't know if there's anything to do with Doug's. I thought that's what was...
His brother owns. And so we're trying to figure out if that's maybe how you came into contact. All these connections, your name came up because you're connected to him through her, and he's connected to the house. You see what we're saying? We're just looking at if it's possible you've ever been there. Because if it's possible you've been there and you don't remember it, that's okay. I mean, nobody's accusing you of going in there and burglarizing the place or doing anything stupid like that. But that's why we ask those questions. We have to dot every I and cross every T. And, there's other things that come up in a case. We have a lot of things that physical evidence that we collect at the time doesn't get processed until later. Like right now, I've got some DNA evidence that we found within our evidence so even 7 years later, I still have stuff that's always new, so it never ends with us. We're always having to get something being tested. Yeah, a lot of people do. We'll be right back. I think we're just about done. We just need to see if our other partner who's working the case with us has anything, because he's out watching your kid. So we'll be doesn't even ask me, but I have to ask. Did you have anything to do with this case? Did you do anything? On occasions, if you've ever been to the house. The reason I have to ask is because, again, remember we talked about forensic evidence, and I've asked you at least on 3 different. That's why your fingerprints were found in the house. That we're going to make this hit on. So that's why I'm asking these questions. Again, like I said, I deal with physical evidence, I deal with people, and there's a lot of things that happen in people's lives. People go through hard times. People who get angry and do things they didn't mean to do. And so that's why we need to talk to you about that. You have no idea why your fingerprints would be in the house. Okay. Well, it's a problem that there are lots of people that we've been able to collect prints from and things like that. People and rule them out. And again, that's why the background investigation on you to find out where your prints are in the house. They go through each one of these. Let me explain what happens when we collect a fingerprint. We have the state crime lab come out, obviously on a serious case like that, and print the whole house. Again, I don't know. That's what I'm trying to say. I don't know. Anywhere near that place, sir. Have ever. You told us you haven't been in the house. I haven't ever been. Back then, actually, when they said, were you taking any medications at that time? And do you have any lapses in your memory from that time? No, the medications I take. Blackouts during that time? No. So I don't know. So nothing medication. No, you didn't have any idea where. Okay. So you don't. I don't know. I have no idea because I didn't. I didn't. Well, we're not saying you did anything. We're just we have to explain why your fingerprints are at the scene of where somebody died. Okay? So, and that's why, we have to go through and do a background and do all that kind of stuff to kind of help us understand who you are. And if you're a person something like this or not. Like I said before, here's the deal. I'll be straight up with you, okay? I know what you're saying. I know exactly what you're saying. I didn't have anything to do with whatever stupid thing. I don't. Nori Jones case, right? Okay, so you understand what we're talking about in the murder. Okay, yeah, absolutely. Yeah, that's what we're talking about. Is Nori Jones the I guess, Brad, what I'm getting at is, help me, help you. I don't know what you know. So we're just trying your fingerprints are there. I don't know, that's what I'm trying to say. I don't know if they're there or what happened. Well, they're there. I mean, we lived it. Help me understand what right here and do that. We wouldn't have bothered to even talk to you if this was playing this little cop game you see on TV where we tell you your fingerprints are somewhere, no, okay. Brad, here's kind of the deal. If this wasn't the situation, I don't remember being there ever, so. Prosecutor and a judge. I understand. Okay. We really want to tell our bosses, okay, you standing here and saying, I've never been there, I have no idea how they got there, I don't know why they would be there. I was never at the house until the day after this happened, okay, clean up the mess, okay, and my fingerprints on. So, where these fingerprints are found inside this place, it's not a place where it would be for a long time without being way disturbed, okay?
time period, okay? And they figure out why your prints were there. Your prints only belong to you. Nope.
It's not going to go away, Brad. We have to resolve this. You're making yourself more a part of it and that's the problem, because
I don't know, thinking that, I don't know what to do at this point, because I don't know. There's an issue, I'd be asking the same question.
What's going on is we're trying to find out.
I know, I hear exactly what you're saying, and I would be, just from my standpoint, I'm like, last time I talked to you guys, I couldn't see you for like a week, and now I'm talking to you. I'm like, thinking to myself, what did I do, where was I at, that type of thing. Sure.
Well, it's 7 years ago, that wasn't wrong.
We didn't know Nori. Did you ever go to her house? Can we go to a party there? That's what I don't know. I remember ever being there, like I told you guys. Did you ever just hook up with a chick and end up there? That's what I'm saying. I don't remember. Think back 7 years ago, okay? 6.5. Did you hook up with any chicks? Go back to their place? If you're right or wrong, you still know that you've done it. Well, I don't really drink. Sometimes it's, more than. I don't remember ever being anywhere near the accused house, so. Okay, well, I tell you, I'm looking just for a reasonable explanation. Right. If you told me, I met some chick at the bar and I went home with her, and I remember I left or whatever. If I had that information, I'd give it to you. Okay. Just saying where we're coming from. We did our thing, and at this point, okay. And here's the deal on this. Brother, major thing, but we're trying to help you out. I'd like to get my name clear, that's what I'm looking. Sure, well, that's what we're looking to do too.
And earlier I had said if we
solved at this point.
then your name's clear. That's why I offered that. Okay. And that's an open offer. We're not occasion test. If everything you're saying is true, I'm offering this tool to you to do that if you choose to do it. If you would like to have that option. What I'm saying is you just want to clear your name.
I'm not part of this. I don't know. I didn't do anything.
I understand that. Nobody's going to opt to a state crime out of that stuff. That's at this time being tested. Okay, like I said before, we've got some evidence. Is any of that going to come back to you? That's cool. You know what? I gotta talk to Scott real quick. I'll be right back.
Yeah, something like that. That's how I see it.
Okay.
Look at what you came in here and you're going home. You're not going to jail tonight. Okay? You're not going to jail.
We keep burping. Well, if you're thirsty, help yourself.
I'm explaining this other stuff to you. Okay? I don't know how to, I'm on disability, and, okay, here's the deal. These type of things in the real world versus what you've seen on TV. School the kids have to work on this. This has gone out of closure on this. Okay? The police department won't do anything about it or have forgotten about it by now. Okay? Not looking at the upcoming thing, it's hot off the press. Most people don't know for putting this case to rest. Okay? We're looking at giving the family some closure. You went to somebody's place and you caused them harm, you caused them death. Okay? We brought you in, we said, yeah, I did it. For whatever reason. I mean, that's up to, because the community is in uproar. Okay? That's why I'm just putting you in jail. You sit in jail. Judge and jury decide what's going to happen. Okay? Well, this isn't like that. This is 7 years old. Full of things, bring open all the wounds. Just want to bury them and move on. I hear what you're saying. And that's where we're at. In jail is, the cops got a job to do, so yeah, we do. Right. I don't know what you think our job is or isn't. Well, our job is to close cases. Okay? And that's what we do. And we don't get an award for making them people to prison or putting them in jail or anything like that. That's not what our goal is. Okay? If that's all, we're sending, taking this information to the prosecutor, say, hey, this is what we got. He has to have done this. We got to get out of the way, and then we can do all this other stuff that we want to. Okay? And that's not how we and I would be happy to do that. Okay? But that doesn't cause there are some police officers who go out and grab whoever we can, throw them in jail for whatever we can. Okay? If we got some big bonus for doing that, like I said, our job isn't just do the thing.
We just want to close the case and give the family something. Imagine if this is
Well, we don't. Okay, exactly.
we could, even 7 years later, so that you could sleep at night and know, okay. And it's not, when you want us to do everything that was killing, how it happened, I mean, they just want to know what happened. Wouldn't you want to know if a family going to bed thinking, I don't know how it happened, I don't know why. Most of them know why. I mean, they've got to deal with this. This poor mom every night. And I'm sorry, I didn't mean to do this. I lost my freaking head. That's what we're. Just the simple fact that somebody's trying to do, and like to take a call and say, we're not looking at what they need, get that closure, and that's what we're trying. Look in your background to see what kind of person you are, to see if you're somebody we could work with some time before we can even talk to you, to find out that opportunity to do that. Okay? Have a chance to talk to us and get out in front of something bad. And that's what we wanted to do. We wanted to imagine what they're going through. We want to help that family. And think about it. I mean, this is your sister, this is your mother, this is your brother this happens to. So, opportunity to get you an opportunity to get something off your chest, to get something, because you're not sleeping. A lot of that. Okay.
I can talk to you guys about expect to go to sleep. I mean,
No, I know that. I mean, it's hard. This is not something that's easy. Okay, this is not something that's just, you had to have known that someday this was going to happen. Yeah, I mean, be honest. Wish you would help us prove that then. You know what? Help us prove that then. If you're saying that you didn't do this, that you, well, I would take her life. If you're telling me that right now, then help me prove that you didn't so I can go find who did. All right?
all I know is that that's the best I think I can do. I mean, I don't want to be in the middle of it. Because
Detective Collins said you are going to go home today. Well, all that's going to happen. And you know what? Like, we will. I mean, we will. And that's, again, like I said before, to get to the bottom of it, okay? And you know that to have that, they've lived 7 years not knowing. And you know what? They deserve it. They deserve the closure. They deserve it. We were in the house that day, so to us, you know, this case will stay with me the entire time. I won't stop, and neither will he. We were there that day to be able to help you. Okay? There's a lot of ways we can. For that family, they've earned it. They deserve it. And we would like,
you know, I hear you guys saying that I need to come clean, you know. I don't know anything about that.
I understand that.
Okay. It's not all you think about, you know, not to answer anything. You say you've never been to, you have a reason to be there, all of that, okay?
You don't know her.
That's a strike against you.
Mm-hmm.
A common layperson, you know, a jury member is going to say. Well, I don't know, my friends got there. What is, but I mean, I've done a lot of stuff that I don't remember what I did, so, I mean,
well, that's what we have to do. Do you think it's possible that
that's what I'm saying. I've been a lot of people, places and found all of human beings, so.
Okay. Okay.
Okay, well, I mean, I'm I mean, after this happened, you've never been back to this house?
No, I don't remember.
Right?
From when?
He died there. Okay.
Yeah, Doug tells me I can't run it because of that.
No one lives at that house. No one's lived there since. And would you want to live at a house where somebody was killed there?
Probably not.
Probably not. It's good for nothing at this point, basically. Probably not. So, that's just what I'm telling you. Being there up until then. I mean, you haven't been there since then.
I just don't remember.
You don't remember the location where his fingerprints were
Until, you know,
okay.
before I went to hotel.
Okay. Like I said, it's not fixing to be the last one. But they're there. Okay. I mean, just common things that go on in a normal house. There's pretty much nothing not processed in the whole house. Okay. I mean, a lot of hours in there. Look for the Kaufmans. It's been there. You know, come back to you. You never construction work in this town. Working for a cop, and I don't remember ever meeting with Doug's brother, so. Okay, you only work doing framing for one guy. Contact with this guy, you can say, yeah, I've done a little bit of other construction work, but nothing. I think I just work for this guy. Okay. And same on anyone. Yeah, I'm pretty sure. Okay. Doesn't mean it's Ralph then, but okay.
they're not going to work with anybody. They've got an opportunity. Once we get the evidence, those prosecutors, they're looking for convictions. They may be willing to work with someone. There's no need to do that. But if that evidence isn't there yet, that's my job. My job is to say, okay, I'm going to bring this party together with this party and we're going to work something out. We get justice. That's how things are done. Again, once I get the evidence in my hand, I don't need it. If I had a person come in here and tell me I had nothing to do with something, and then turn around, and then I get the evidence that shows them, well, do I take it personal when people lie to me? I do. I'll be honest with you, I do. There's one thing that I hate in this job more than anything else, and that's when someone makes me angry. Because I go out of my way to try to be honest and upfront with them. I haven't lied to you here. I haven't told you anything that's not the truth. I've gotten fingerprints. Yeah. Is he being honest with me? And I think you're being as honest as you think you can be. I think that I look at is I look at some point things are going to get to the point where, you know what, I know you said you can't wait for just the cuffs to get on. Well, if I keep suspecting here, it's like, well, we got your fingerprints, you're going. But we told you. What I'm thinking that, you know, why are my fingerprints there? Well, that's what we're thinking, and so that's what we're working on. Well, that's not. It is, okay, let's swap seats, okay? I'll be you, you be me, and let's say that I'm your employer and you're my employee, and we're working on it. Let me ask you who are my employees and I'm the owner of the store. And let's say this, let me ask you this. You come in and you notice stuff, he's my employee, okay? So you something there, little things like this and that are missing. So you put up surveillance cameras, technology, the shelves, little things, a candy bar here, just you have taken something, or I see, not just you taking something, but I see him taking. Now you see, not my employee, I bring him in and I say, let me ask you, I bring you both in separately, and I bring in this detective, or sometimes employees help themselves to these things. If that's the case, and you just, the paper inventory is missing. Now it's not major stuff, it's a candy bar, and so thinking, I'm sorry, it was stupid. Okay, then I bring in the next employee. What I did, I took a couple candy bars, and you know, I'll pay for them out of my check. I just wasn't. Some candy bars missing, some things like that. So let me ask you something. I've had some shortages. I found it wasn't me. I don't know who you got, but it wasn't me. I haven't taken anything. And you say, yeah, but I've got your video. And are you going to fire one of these two? And they say, I didn't take nothing. Okay, now, if you're an employer, honesty goes a long ways to, yeah. But which one's going to be the guy you probably keep? Probably the guy I know. That's right. I'll tell you what'll hurt you. Situation is, as far as the level of trouble you're in. Honesty's going to go a long way. Because in the end, getting caught in a lie, that's the worst. Because once you've lied, nobody will trust anything you say after that. Nobody will trust anything. Let's say you took this car, okay? You went and you jacked the car, and I later on investigated. It wasn't me. And I say, okay, fine. Then I come back, and not only do I get your fingerprints in the car, I get your DNA on the steering wheel, and I can prove that you're in. So, I didn't really take the car. I was just kind of joyriding it, and I just borrowed it for a bit. I ain't gonna believe you. You already, and then you tell me, well, and at that point you said, screw you. I don't know what you're talking about. I don't want that to happen in this case. To be straight, emotion, you're scared right now. I would be too. I'm not going to lie to you. Sitting in a police station, tell there was something going on. You've got a lot of... I do applaud the fact that you came in here voluntarily. That goes a long ways. I applaud the fact that it is for you. I do applaud your brave. You can do that. You know that. I mean, we've made that abundantly clear. And I've asked you a couple of times, do you want to stop? Because you can still walk out anytime you want. That's all I know. And so are we. And that's exactly what we're trying. Asking questions until you get a lawyer. Well, I'd like to have you guys get to the bottom. And then once we get the evidence we need, we won't need to talk. At some point, we're going to get what we way up, because like he said, it's out of our hands, it goes to the prosecutor. Right now, our ability to help people do what they want to do, regardless of what we recommend. Once that stuff comes in, it's out of our hands, and it becomes their ballgame, and we're cut out of the loop, and they're going to help you figure out why does we want to work with you. We want to help. Some things that you've told me haven't been true. I know that too. Okay, I know some things that you told me today have been true. I know that. The point up to bring this point up is that little things make a big difference on how things look. No, you know what? I'm not judging you or saying anything. I brought that significant. If you think about it and it pops into your mind, you need to tell us. Because we go to school, important that, you know, when we ask you something that, even if it seems insignificant, you're creating a memory. How you position your body tells us, how eye movements, where your eyes go tells us if you're recalling something or if you're years in law enforcement. We've been to all kinds of, you're being honest, whether you're concealing something. I mean, between the two of us, you're looking at over 4. Get to a point where we're comfortable saying, that's good, it's our job, we have to do that.
Your Honor, I know for the rest of the video there's no more audio, but there's right now 1 minute and 34 seconds left.
Thank you.
I confirm that as well when I watch the.
Thank you, gentlemen.
Your Honor, at this time, I would ask that State's Exhibit Number 36 be returned to the custody of the court.
Very well.
And no further questions at this time for the witness from the State.
All right, thank you, Mr. Trammell. All right, folks, we're past our noon recess time, so we'll go ahead and take our lunch recess. And if you would all be back here by 1:20, we'll get started at 1:30 in court. So during the lunch recess, again, I instruct you not to discuss this case amongst yourselves nor with anybody else, nor to form an opinion as to the merits of the case until after it has been submitted to you for your determination. Enjoy your lunch.
All rise.
Be seated. And we are still on the record outside the presence of the jury. Counsel for both parties and the defendant are present. Okay, so Mr. Andrew, we'll let you do cross. Afterwards, then, after Detective Bush, we're going to have Ms. Hall and then Mr. Cutler. Is that correct, counsel?
We'll take there's a brief chain of custody issue. We'll take up with Idaho, as that will take just a couple of seconds. And we'll do that before we get to City Hall and Mr. Cutler.
All right. Anything else we need to take up, counsel?
No,
No, I'm going to talk to Mr. Trammell about the name change order.
Okay. All right. Appreciate that. Very well. All right. If you would all be back here by 1:20. We'll start at 1:30. Enjoy your lunch. Be in recess.
All rise for the court.
Just so you don't have judicial. I think that's a whole.
Well, Scott, the reason, because I didn't think I could get through
You can, but now I'm starting to allow it in by judicial notice, and I like that less than just stipulating to it at this point. Submitted it on the recorder, so rather than try and screw around it and I was, because I didn't want him taking judicial notice. He's done it.
But if you
So
would
I
have
gotta deal with it.
to something else, I would have done that too.
Do we need to do anything like,
So we can either spend a half an hour trying to figure out what we're gonna do. What's your judicial notice instruction, or just do it
do you want, which would be a difference if the case was certified? Do you want us to have a court just for yourself?
If you want to go get a certified copy, I'll just say, Your Honor, I'm not going to reject. I've got the certified copy now.
I'm fine.
So I'm just saying at this point, if we want to make it simple, rather than deal with whatever the instructions can be.
Probably too soon, sorry, probably too soon. Sorry.
Well, I was trying to keep it out. And it's not going to
Coming in,
now
it's
it's
just
going
to
to
do
come
it.
in worse than what I want. So, but it's just the order.
Wait, I can talk to Commissioner about getting certified. That's
Let me look at it, just
Or even offer that and say, based on your findings, judicial notice. I'll just say, I'll stipulate that they want it's way easier than doing something.
Well, I was thinking about it.
I hate to say it, but there's such a disaster.
No, you're the one that kicked it over. He keeps it under that chair.
So sometimes when I have like garbage, I just put it. I'm not reaching in there. You get a bit.
You in there?
Fine.
Yeah, in fact, the library will be in that room at the rally.
That's okay.
I hate to say it, but yesterday was such a disaster.
It was,
I just ordered from Subway. Once I have your order, I just try to place order again.
Albertson's Deli is awesome. I got food from there.
Yes, they do want to get some.
Hey, that's good. No, Albertson's sushi's good too. It is. It's down there. I went over there yesterday. I used to say anything sausage.
That isn't it, that's a basis. Please. And I'd say you gotta, that comes down to how do you fight that? Because the only way
You can see on those, it's like, how much
But I know I can have it open my history when I was hobby.
Instead of just like, vacuum your car, and you know what it sounds like. That sounds like it has something outside the page.
There won't be an extension.
Yeah.
All right, come find me.
Unless you tune up, I mean, I don't know. So,
We ordered it. It's the lines at the door.
It's coming out.
Oh, yeah.
shipped up
What do
or
we got?
it's
I
packaged
don't
in.
order for you.
Which means you don't.
There's like certain days that are pressure.
Simusu fly stuff. Simusu down there, they fly stuff in.
The Hokkaido's good. No.
I don't like, Tokyo Bell.
We didn't talk about a number of machines.
Alright.
And I had that experience.
I had to We're all holding. And then, 120 up here. What is that?
I'm gonna
Yeah.
have 130, so 120, yeah.
20.
So I'll be back here and go grab lunch.
Okay, let's roll.
No. Wait, I ordered you, one of his, he's getting one of his, she's a Dr. Pepper boy, but I can get whatever. It's fun.
She finally gave me the courage to talk to you.
Get the caffeine from the monster. Yeah, I just know if I go over there, we'll be ready yet, so I'm just lingering for 5 minutes and then I'll wander over.
So, I wonder
You don't want to tell anybody that.
It was weird.
Yeah. Bell comes, but I can listen to it. Sure. Vegetarian, I don't think the coffee.
vegetarian gentlemen. Sometimes they have to do
Right.
it's just not the meat. So it's the
There are no,
CR 2014-12727. The State's Counsel, Defense Counsel, and the defendant present in the courtroom. We are outside the presence of the jury at this time. Any matters need to take up, counsel?
Just one, Your Honor. I've been talking to Mr. Trammell in, I believe it was in the discovery, but I was given a copy of the petition for name change, the order of name change. That copy had a certified, it had a certificate from the clerk that it was a copy of the original. And if the state's going to offer that, because I know they have it, if they're going to offer that, obviously it's self-authenticating, and that will hopefully avoid our judicial notice issue. But I have it, Your Honor, so I can't sit here and tell you I don't have. If they're offering it because it was provided in discovery, I have it.
Okay. Is that accurate, Mr. Trammell?
Your Honor, I know we're looking for it right now. We did get another packet of it certified today. I think the defense is going to be objecting to that for now, but we are going through our records to see the one that Mr. Andrew has, where it's at.
One that was previously produced through discovery that had the certification?
Yes, Your Honor.
Okay. Okay, anything else?
No, Your Honor.
Anything else from the state before we bring the jury in?
Not from the state, Your Honor.
All right. Mr. Reiner, bring the jury in, please.
I'm looking, I want to say 20, you guys sent me as 23, I think. I'm looking.
All rise for the jury.
Please be seated.
You know, I just remembered one matter. If Mr. Andrew and I could approach, it's
Yes.
something we can take care of
Go.
at the bench. Scott.
Good afternoon, ladies and gentlemen of the jury. Hope you had a good lunch recess. All right, all jurors are present in the courtroom, seated in the jury box. Will counsel waive roll call of the jury?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. Mr. Andrew, cross-examination.
Thank you, Your Honor.
And before that, Mr. Bush, you understand you're still in a row, sir?
Yes, Your Honor.
Thank you. Go ahead, Mr. Andrew.
Officer Bush, there was Exhibit 41, which showed her right hand. Could you be handed Exhibit 41?
Yes.
It showed Miss Jones's right hand. Do you recall there being her having any rings on her right hand?
I don't recall that.
Okay. And if I recall correctly, you didn't attend the autopsy.
I did not, no, sir.
Okay. I want you to look at that photo and see if you can identify anything that looks like a gold type band on one of her fingers.
I don't believe I see anything.
Okay. And if you can you can go ahead and return the exhibit. At the beginning of this interview, you indicated that you had shown Mr. Compher a picture before you came in the room.
Correct.
Do you recall what picture?
I believe it was a picture of the house to show where it was, to see if he recognized it.
Okay, but was it, what was the vantage point?
It would have been exterior, like from the roadway, like as if you were driving by.
Okay, so from pole line looking west towards the front of the house?
I believe so.
Okay. And you indicated also in the interview that there were hundreds of pieces of evidence?
Yes, sir.
Okay. Do you know how many of those had been sent to the lab?
I could not answer that, sir, no.
To this day, do you know how many items were sent to the lab?
I could not answer that. I know it was numerous, but...
Fair enough. Anything? Those are all the questions I have, Your Honor.
Thank you, Mr. Andrew. Mr. Trammell, any redirect?
Brief redirect, Your Honor.
Go ahead.
So, Mr. Bush, when Mr. Andrew was asking that you showed a picture of the house, to clarify, was that Nori's residence on Pole Line?
Correct.
Okay. That you showed Mr. Compher
Correct.
before the interview started?
Correct.
Okay. Thank you. Nothing further.
Thank you, counsel. May this witness be excused.
He may.
Yes, Your Honor.
All right, sir, I'll excuse you. I just need to advise you again, make sure you don't discuss your testimony with any other witnesses in this matter.
Yes, sir.
Thank you, sir. You may step down. All right, state's next witness.
State calls Cindy Hall.
Ma'am, if you would come up in the well to my right, raise your right hand before Ms. Holm, our clerk, to be sworn.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Please have a seat in the witness stand. Mr. Radford, you may inquire.
Ms. Hall, please state your full name and spell your last name for the record.
Cynthia Hall, Hall.
Ms. Hall, what is your profession?
I am employed as a senior DNA analyst with DNA Labs International, located in Deerfield Beach, Florida.
Okay. Do you live in Florida?
I do not.
Okay. You're still here in the great state of Idaho.
I am. I still live in Idaho.
And in 2014, how were you employed?
I was employed as the quality manager for the Idaho State Police Forensic Services Laboratory System.
And how long were you with the Idaho State Police Forensics team?
In 2014, I believe I had been there about 10 years, but in total, I worked for the Idaho State Police for approximately 20 years. I left to go to the DNA Labs International Laboratory at the end of 2020.
Okay. Now, in order to work at the state lab, is there any education that you would need to attain to be able to hold those positions?
Yes. Well, there's education to work in forensic sciences, and then there's also specific education to be a DNA analyst. So in order to work in the field of forensic sciences, a requirement of a minimum of a bachelor's degree in a science is required. And then to work as a DNA analyst, I'm also required to have coursework in biochemistry, genetics, molecular biology, and statistics.
Okay. Now, in 2014, was there any accreditation you needed to have or any personal licensing that you needed to have to be a DNA technician?
There's no requirements for certification to be a DNA analyst. However, at that time, I did hold a certification. I was certified by the American Board of Criminalistics in molecular biology.
Okay. So at the present time, how many years of experience do you have as a forensic scientist?
Approximately 30.
Okay. And is that all in DNA testing and analysis?
It is.
Okay. Are you familiar with, well, let's do this. Is there any continuing education that you're currently engaged in?
Yes, there is a requirement for DNA testing that every analyst must receive a minimum of 8 hours of continuing education each year. I do receive at least 8 hours per year. Most years I receive more than 8 hours per year.
Okay. Now in 2014, were you a member of any associations connected to forensic testing?
Yes, at that time I was a member of the American Academy of Forensic Sciences, the International Society for Forensic Genetics, the Association for Crime Lab Directors, and a member of the Quality Assurance Managers Association.
Are you familiar with ABC?
Yes.
What does that stand for?
ABC is the American Board of Criminalistics, which I mentioned I was certified by them in molecular biology.
Okay. Have you ever testified as an expert witness before?
I have.
How many times?
Approximately 70.
Okay. Have those been in the state of Idaho, or where have they been?
Most of those have been in the state of Idaho. I have also been qualified in the state of California, as well as the Commonwealth of the Bahamas.
Okay. That must have been a fun trip.
Actually, that one was remote. I didn't get to go.
At this time, the state moves to qualify Ms. Hall as an expert witness in the field of DNA analysis under Idaho Rule of Evidence 702.
Any objection, counsel?
Judge, may I ask a question in aid of objection?
You may.
Ms. Hall, I heard that you, to hold the positions you've held, it required at least a bachelor's of science. I didn't catch what your educational background was, though.
Sure. I have a Bachelor of Science in Biochemistry from the University of California, San Diego, as well as a Master of Science in Biological Sciences from San Jose State University.
So, Judge, understanding that, I don't have an objection.
Very well. State your request shall be granted.
Okay. Let's talk about DNA testing briefly. We heard a little bit about this yesterday. Maybe you can refresh our recollections. What is DNA?
DNA is essentially sometimes referred to as the blueprint for life. It is found throughout our bodies. It determines who and what we are. It differentiates us from plants and animals. It gives us our basic human form, so 2 arms, 2 legs, etc. It determines how our bodies function, as well as differentiates each of us so we have unique characteristics so that we don't all look exactly alike.
Okay. Now, so I'm guessing there's portions of DNA that are identical from person to person.
Yes, over 99% of DNA is the same for every individual, and because, like I mentioned, it's the blueprint for our bodies. That's what determines our function, human functions, our human form, and so that has to be the same for everybody. Otherwise, we wouldn't all have the general human form. But less than 1% of the DNA is actually unique for every individual, with the exception of identical twins.
Okay. Now, when you are conducting DNA testing, what portion of the DNA strand are you looking at?
The DNA testing that I do looks at various locations on the DNA strand that are contained within that less than 1% of DNA that's unique for individuals.
Is there any standardization as to which locations you look at?
Yes, within the field of forensics, there are standard locations that are used throughout the community.
Okay, and how many are there?
Currently, there are at least 21 locations, but most of the chemicals that we use contain 23 or more.
Okay. Now, thinking back to 2011 at the Idaho State, or 2014 at the Idaho State Lab, how many markers were you working with at that point?
At that point, the laboratory was looking at 16 different markers, one of which determines whether a person is genetically male or female.
Okay. Now, in terms of those 15 markers, I'm assuming you're familiar with the literature in terms of uniqueness?
Yes.
Okay. Have, not counting identical twins, when looking at those 15 markers, have any two people ever been found to have matching DNA or identical DNA?
For all 15 markers, not that I'm aware of.
Can you tell me what PCR is?
PCR is the process that is used in DNA testing. It's also sometimes referred to as molecular Xeroxing. It's the process of isolating the particular locations on the DNA strand that I'm looking at for my testing, and it copies those locations over and over again. So essentially, by the time I'm done, I have millions of copies of these specific areas of DNA, which allows me to visualize that as a DNA profile using instrumentation.
Now, after you perform this PCR process, what substance does it take? Is it in a liquid or a solid?
I'm going to back up just a little bit. There are a few steps before we get to the PCR process that's used in DNA analysis. The first step is called extraction, and that's basically taking a sample. Let's say I have a blood stain that I'm working with. I will actually cut a small portion of that blood stain off. I'll put it in a tube, add chemicals, expose it to heat, and that process allows all of the components of that sample to break open and allow the DNA to become free-floating in this liquid. I'm then able to purify that so that I've separated the DNA from everything else that was in that sample, so other cellular components, any debris that might be present. And that extract of the purified DNA in liquid form is then subsequently used for additional tests, including the PCR process.
So can you take that DNA material, and is that put in a liquid?
Yes.
And can that be sent to other forensic analysts?
Yes.
And do you do that on a regular basis?
Send it to other forensic analysts, you mean? Not routinely, but that extract is retained so that if there needed to be testing performed in the future, it would be available.
Okay. Now, this PCR process, is that reliable?
Yes.
Okay. Is it possible for there to be errors in that process?
There's always possible to be errors since humans are involved in it. There can be errors. However, there are many steps that are put into place to either minimize errors or to catch them if they do occur. And with that, I mean, say, a transcriptional error or something like that that we would catch. The PCR process itself, there aren't really any errors that are known to happen within that process.
Now, is this process scientifically sound and accepted within the scientific community?
It is.
Okay. Now, can you tell me what a short tandem repeat is?
Short tandem repeat, or also referred to as STR, is the type of DNA that I'm looking at. So if you remember, I talked about I'm looking at specific locations on the DNA strand. And the reason I'm looking at these locations is because they contain short sequences of DNA that are repeated subsequently a certain variable number of times. And everybody can have a different number of repeats, and that's what differentiates each of us from one another. So the DNA profile that I obtain at the end is a series of numbers, and those numbers represent how many repeats that individual had at each particular location.
Okay, now this STR process, can you do that with touch or transfer DNA?
Yes, so STRs is the type of DNA. PCR would be the process that's used for the analysis. And that process can be used with any type of DNA, assuming there is a sufficient amount of DNA present.
Okay, thinking back to 2014, your time that you were employed at the Idaho State Lab, are you familiar today with the standards and protocols at the state lab as they existed then?
Yes.
Okay. That time when you received an item into evidence, or you received an item from an outside agency, how was that typically handled?
When items are received by the laboratory, they can be received a couple different ways. Either someone from the submitting agency can come to the laboratory and deliver those in person by hand, or they can be received through a courier such as UPS or FedEx. When those items are received at the laboratory, they're logged into an evidence management system. So they're first given a unique case number that is used for tracking and identification in the laboratory. And then each item is given a unique evidence item number also for tracking purposes. The person receiving that item will check to make sure that it is in a sealed condition before receiving it. If it's not sealed, they would not accept it at that time. And then once it's logged in, it's placed into a secure location, either a refrigerator or a freezer or a evidence vault, depending on what the item is.
Okay. Now, when would you get a hold of the items that would be tested?
The evidence stays in that secure location until I'm ready to do the testing. And at that point, when I'm ready to start my analysis process, I will actually go to the individual that has custody. They're referred to as forensic evidence specialists. And then I will receive that item from that individual and document the transfer to me via chain of custody.
Okay. Now, do you take any precautions to keep your workstation clean, or at the time that you worked at Idaho State in 2014, did you?
Yes.
Okay, can you describe those for the jury?
Yes. There are several steps in place to try to keep things clean and try to avoid any potential contamination between items. The first step is to wipe the bench down itself with a bleach solution and let that sit and dry. Then a clean piece of butcher type paper is placed onto the laboratory surface. The items are opened one at a time. I will open, or I did open one item, examine that on the clean paper, take my notes, take my samples as I need them, and then I will repackage that, change the paper in between, clean the surfaces before opening another item, as well as wearing personal protective equipment, both to protect myself and also the evidence, such as a lab coat and gloves.
Okay. Do you recall doing any testing in connection with this case?
Yes.
Okay. At the time that you did testing in connection with this case, were you familiar with a DNA profile that was derived from a LabCorp item number 78/296-1?
Yes, I believe 78 is the Idaho lab number. Yes.
Yes. And what was that DNA profile derived from?
That was a DNA profile that was obtained from swabs that were collected from a possible handprint on a window.
Okay. Now, did you receive any items in connection with this case to analyze against that profile?
Yes.
I'm holding in my hand what's been previously marked for Evidence of States Exhibit 22B. I'll ask that be handed to the witness at this time. Then I'll ask it be shown to defense counsel first.
The witness has Exhibit 22B.
Okay. Ms. Hall, do you recognize that document?
Yes.
What is it?
This is a page from my examination notes.
Okay. Was that document created by you?
It was.
And was it created at the time that you did the testing?
Yes.
Now, when you test an item, well, let me ask it this way. At the time that you were working at the Idaho State Lab, and you tested an item, would you generate a document like this every time?
Yes, I would.
Okay. And would you have access to this document over the course of your employment at the Idaho State Lab?
Yes.
State moves for admission of 22B.
Any objection?
No objection.
State's Exhibit 22B shall be admitted.
Okay. Now, looking at that document, Ms. Hall, does it describe the item of evidence that you received for testing in this case?
Yes.
And what was that?
It was a cigarette butt that was to be used as a reference for Brad Compher.
Okay. Now, when that came into ISP custody, what condition was it in?
It was packaged in a manila envelope that was sealed with evidence tape and initialed.
Okay. Now, did you apply the PCR-STR process to this cigarette butt?
Yes, I did.
Okay. And after doing so, did you generate a report of your findings?
I did.
Okay. I'm holding in my hand what's been previously marked for evidence of State's Exhibit 22. I'll ask that be handed to the witness at this time.
Witness has Exhibit 22.
Okay. Ms. Hall, do you recognize that?
I do.
That document. What is it?
It is a copy of the report that I produced regarding my examination of that item.
And when you're doing examination of an item, do you generate a report like this every time?
Yes.
Okay. And is that something that you would have access to over the course of your employment with the Idaho State Lab?
Yes.
And does it accurately represent the findings of the testing that you've just described?
Yes.
This time the state moves to admit Exhibit 22.
May I ask some questions in any of the objection, Judge?
Yes, you may.
And Ms. Hall, just to make sure that I understand, I don't know that we heard it specifically, you performed an STR test on what's in front of you in that report. Is that accurate?
That's correct.
Okay, and this is the result of that STR test. Is that
yes.
accurate? Okay. Judge, I don't have an objection.
All right. Exhibit 22 shall be admitted.
Okay. Now, so just so we're clear, the testing that you did in this case, is this an accurate way to frame it? You were trying to pull DNA off of that cigarette butt and then compare it to the DNA from the window swab?
Yes, I'd say that's accurate.
Okay. Well, let's talk about your results in that. I'm looking at Exhibit 22. It identifies item 28 as the cigarette butt that was to be used as a reference for Brad Compher. Can you tell me what your conclusions were following this testing?
Yes. I was able to obtain a DNA profile from that cigarette butt using the PCR process, and then I compared that profile to the profile I had received for the swabs from the window. I was able to determine that the DNA profiles were the same, so that allowed me to indicate that those two profiles were a match.
Okay. Now, you mentioned that you pulled a DNA profile from the cigarette butt. Do you know how many locations you identified from that cigarette butt?
Yes. The testing that I did looked at the 16 different locations, and as I mentioned, one of those is a location that determines whether somebody is genetically male or female. So I was able to obtain results at all 16 of those locations.
Okay. Now, with the swab from the window, do you recall how many locations were available from that profile?
11.
And so when you say that you matched the profile, was it at the 11 locations that were available from the window swab?
Yes, that's correct. Since there were only 11 locations that the laboratory was able to obtain results at, those 11 are the ones that I was able to compare to the DNA profile that I obtained from the cigarette butt.
Okay, now under conclusions and interpretations, I'm looking at the last line there. It says, therefore, Brad Compher is the source of the DNA on this item, and then there's a subnote, which points me to subnote 2. Can you just explain I guess your reasoning that allowed you to make the inference that Brad Compher was the contributor of that DNA?
Sure. So anytime I do a DNA comparison and in the community as a whole, if there is DNA profiles that are the same, so in other words, I'm not able to exclude an individual as being a possible source of the evidence DNA profile, then I generate a statistic for that evidence profile to determine how rare or how common that DNA profile might be. It essentially gives some weight or gives an idea of what that match means in that particular instance. So I calculated a statistic in this particular case, and then at that time the laboratory adopted a reporting system where if the statistic that was obtained exceeded a specific number that is relevant to a given population, in Idaho, that was the population of the state of Idaho as well as the 6 surrounding states, then that DNA profile could be considered to be unique within that population, excluding a genetically identical twin.
Okay. Now, I'm looking here also at subnote 2, and you note that these profiles, where they were matched at the 11 locations, have an expected population frequency of less than 1, and there's a funny little number there, 9.3 times 10 to the 13th power. I'm not good at math. Can you tell us what that number is?
Yes, so let me explain what this is, and then I'll give the number. So that is the statistic that I calculated for that particular profile, those 11 locations that were obtained. That is referred to as a random match probability. So that essentially tells me the probability of seeing that profile in the population. So the chances of randomly selecting an unrelated individual from the population that would have that profile is this statistic, and that is 1 in 93 trillion.
Now, did you do any follow-up testing in this case?
On this particular item or in general?
No, in general.
Yes.
Okay. Did you receive another item for comparison against that window swab?
I did.
Do you recall what that was?
Those were known samples, including oral swabs from Brad Compher.
Okay. I'm holding in my hand what's been previously marked for evidence as State's Exhibit 34B. I'll ask that be shown to defense counsel and handed to the witness.
And the witness has Exhibit 34B.
Okay, Ms. Hall, do you recognize that?
Yes.
What is it?
This is a copy of a page from my examination notes for the samples received from Brad Compher.
Okay, did you generate that document?
I did.
And did you generate that document at the time that you did additional testing?
Yes, I did.
With the items that you've described?
Yes.
And when you do testing, do you always generate a document like that?
I do.
And is it available to you through the course of your employment?
Yes.
At this time, State moves for admission of 34B.
No objection, Judge.
34B shall be admitted.
Okay. So just describe for me what this item was that you received for further testing.
This was, it was received in a sexual assault evidence collection kit, which is essentially just a box that contains various swabs that can be used to collect samples from an individual's person. The kit contained samples including a blood sample, some hairs, and some oral swabs that were said to be collected from Brad Compher.
Okay. And so when you say it was said to be collected from Brad Compher, are you indicating that this was to be used as a reference for Mr. Compher?
Yes.
And would you classify this round of testing as confirmatory testing?
I would.
Okay. And did you test it in the same manner that you tested the cigarette butt?
I didn't test every item in the kit, but I did test the oral swabs. And yes, it was the same testing process.
Okay. Holding in my hand what's been previously marked for evidence of State's Exhibit 34. I'll ask that that be handed to the witness after being shown to defense counsel.
Witness has Exhibit 34.
Okay, Ms. Hall, do you recognize that exhibit?
Yes.
Okay. What is it?
This is a copy of the report that I generated regarding my DNA testing on the oral swabs.
And all the conditions that we previously talked about with your prior reports, is this report kind of the same thing?
Yes, it is.
Okay. The State moves for admission at this time.
No objection.
Exhibit 34 shall be admitted.
Okay. Now, for this round of testing, did you test the sex assault kit against the same DNA item, which was the window swab?
I tested the oral swabs that were contained in that kit and compared it to the DNA profile from the window swabs.
And did you also receive a match on this item?
I did.
Was there anything significantly different than from the cigarette butt?
No, those profiles were the same.
Okay. So are we ending up with the same statistical conclusion here?
Yes, because that statistic is calculated using the profile from the evidence, in this particular instance, the DNA, the swabs from the window, so the statistic is the same.
Okay. So is it accurate to say that both the cigarette butt that you tested and the buccal swab to be used as a reference for Brad Compher matched the window swab?
Yes.
No further questions.
Thank you. Cross-examination.
Thank you, Judge. Ms. Hall, just to clarify, item number 78, as you've described as the window, right?
Yes.
You didn't retest that window, correct?
That's correct.
You were taking the results that were provided for you from a prior test. Is that accurate?
Yes.
And then you're comparing the results from your STR process to those results?
That's correct.
Okay. Do you do anything to verify that the results of 78 are accurate?
I was provided with the note packet that was generated by that laboratory. It contained all of the worksheets and the testing materials, as well as the data. I did review all of that to make sure that based on the documentation that the results appeared to be intuitive, but I'm not present at that laboratory when the testing was done.
You've also mentioned that when you received the item, so item 131 or item 128, you're relying on the description that's provided in that, the packaging, correct?
Correct.
You're not aware of whether or not, I should say, you're not present when any of those samples are collected.
That's
Is that
correct.
accurate?
Yeah.
So as far as whether or not that actually came from Mr. Compher, whether that cigarette actually came from Mr. Compher, you're relying on what's been included from the police.
Yes, that's correct.
There. Okay,
Yeah.
thank you. A quick question. You had mentioned that at the time in 2014 you were considering 16 different loci?
Yes.
On, let's see, it's the second page of exhibit, let's say, which exhibit do you have in front of you right now?
34.
Could you look at the second page of that, please, or page 2 of 3?
Yes.
This is in the postscripts. There's postscript 1 and postscript 2. Do you see those?
I do.
Now, maybe I'm reading this wrong. In that first line there, it seems to indicate that there's only 15 STR loci. Can you confirm that for me?
So the first line refers to the gender identity locus, which is called amylogenin. That's the 16th marker.
Okay. I saw 15 and thought I'd better ask. So, do you specifically remember testing items 128 and 131?
Yes.
So you specifically remember going through the process you described earlier of putting bleach down on the table and putting crepe paper down. Do you specifically remember that?
I don't specifically remember that, no, but that is my normal process.
And I assume you were, I don't know if you said gloves, I remember hearing the paper and the bleach. Do you put on gloves as well?
Yes, gloves and a lab coat.
Okay, thank you. Now, is there anything in the samples that can indicate when the samples were placed? We know, let me strike that, let me back up. You know when the sample's collected because of what's on the packaging, correct?
Yes.
You don't know when the source of that sample was ever placed at that point.
So are you asking if I know when the actual DNA was deposited on the item?
That's what I'm asking.
Yes. No, I don't know that.
And that's not something that DNA evidence can do. Is that right?
Yeah, that's correct.
Do you have a way of knowing how long that DNA evidence had been placed there?
No, my testing can't determine that either.
Not all DNA testing is created. Well, strike that again. When the strength of your results depends in large part on the strength of the sample. Does that sound accurate?
Yes.
So if your sample doesn't have much DNA in there, you can't get a very conclusive result. Does that sound accurate?
I wouldn't say conclusive. It depends, but that is correct. If there's not very much DNA present, you may not be able to obtain what we call a full profile. So it's possible that results at all, in this example, 16 locations, we may not get results at all 16. We may get results at 14 or 10 or even fewer. And it is possible that if there is such a low amount of DNA that we may not get results at all, or if we only get results at, say, 1 or 2 markers, that wouldn't be enough to do any kind of a comparison.
So when you do the PCR, that is really just copying the DNA, correct?
Yes, specifically those locations.
So if you don't have very many locations, your PCR doesn't help create more locations. Is that
That's
right?
correct, yeah.
Okay. You've talked about excluding individuals. So if I'm understanding DNA correctly, it's about being able to say statistically whether or not a sample matches another sample, or excuse me, whether or not a profile occurs so often in a population.
Yes.
And certain DNA testing is more discriminatory than other DNA testing. Does that sound accurate?
Yes. For example, there is a type of DNA testing called YSTR testing, and that looks specifically at male DNA, and that's inherited through a male lineage. So a father is going to pass that same Y DNA profile on to sons and so forth. So that would not identify a specific individual. It would potentially identify a family line, a male family line.
So the STR you can narrow down to one person. Statistically, right? That's what we're talking about, is statistics, correct?
Yes. The reporting system that the state police used in 2014 allowed a conclusion to be made that if the statistic was above a certain number, then that profile could be considered to be unique. So yes.
It all depends on whether or not there's enough loci to match with different samples.
Correct. The fewer loci you have, the smaller that statistic is going to be because there's not as much information. The more locations that you have that match, the higher that number is going to be. So if you have very little DNA and just a very partial DNA profile, that statistic could be much smaller.
Now, if you could look at, I think we're on the right one. The State's Exhibit 34 is in front of you, correct?
Yes.
On the first page, on the evidence description, item 131, what is that called?
Sexual assault evidence collection kit containing known biological samples from Brad Compher.
So the sexual assault evidence kit, this is just a tool that is typically used to take samples from a person's genitals. That's not accurate?
That's part of it, yes. So it contains multiple different swabs to use to collect possible evidence from individuals. It can include genitalia, it can include skin swabs, it generally includes either a known blood sample from that individual or oral swabs, also referred to as buccal swabs, to be used as a known sample. It can also contain hairs. Generally, it is used for the collection of evidence in, say, a sexual assault type situation. However, occasionally it is used to collect just known samples from an individual.
No other questions, Judge?
Thank you, Mr. Fry. Any redirect, Mr. Radford?
Yeah, briefly. Now, the testing that you did in this case was not YSTR testing.
That's correct.
Okay. So in this case, the testing that you did, you were looking at the 15 markers that are independent of gender and then the gender location as well?
Yes.
Okay. Now, you mentioned that there were 11 locations on that window swab profile, and that led you to the calculation of the expected population frequency of less than 1 in 93 trillion.
Yes, the statistic is the chance of observing that profile in a randomly selected population is 1 in 93 trillion.
Okay, is that 1 in 93 trillion or less than 1 in 93 trillion?
The report, I believe, says less than 1 in 93 trillion.
Okay. Now that number, 93 trillion, does that exceed the world population?
Yes.
Okay. I don't have anything else.
Thank you. May this witness be excused, counsel?
Yes, Your Honor, and she is released from her subpoena from the state.
Yes, Judge.
All right. Thank you, ma'am. You may be excused. I need to give you a warning, however, you're not to discuss your testimony with any other witnesses in this matter.
Okay.
Thank you, ma'am. You may step down.
All right. Thank you.
Mr. Radford, state's next witness.
State calls Garrett Cutler. That's already done. It was a non-issue.
All right, sir, if you would, come forward to my right, raise your right hand to be sworn by Ms. Holm.
Do you solemnly swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Have a seat in the witness stand. Mr. Radford, you may inquire.
And Mr. Cutler, what is your profession?
I am a forensic DNA analyst. My current job position, however, is Laboratory Director of Operations.
Okay, and where is that at?
The current employer is Intermountain Forensics in Salt Lake City, Utah.
Okay. Now, did you work for Sorensen Labs at one point?
Yes, I did.
And in 2014, were you working for Sorensen Labs?
Yes, I was.
Okay. And at that point, how long had you been at Sorensen?
At that point, it was around 3 years.
Okay. Do you have any education that allowed you to be a forensic analyst?
Forensic DNA analysts have specific requirements given to them by the FBI that gives those requirements. It is a bachelor's degree in specific science, and you have to have specific courses within your degree, as well as a 6-month training program.
Okay, so where did you do your undergraduate?
I did undergraduate at Southern Virginia University.
And what was your major?
Major was in biology.
Did you take those courses that you mentioned?
Yes, I did.
Okay. Now, have you done any lab work at any universities?
I started off doing laboratory work at a research lab at the University of Nebraska.
Okay, at this point, about how many DNA cases have you processed over the course of your career?
Over the entire career,
Yes.
right now? Around 3,000.
Okay. Now, how many have you reviewed?
Over 5,000.
Okay. Prior to testifying today, have you ever been certified by a court as a DNA forensics expert?
Yes, I have.
How many times?
46, I believe.
And what states have you testified?
I would need a list to get all of the states: Utah, California, Hawaii, Washington, Oregon, Alaska, Arizona, Florida, Georgia, Washington, D.C., Wisconsin, North Dakota, Tennessee.
Just state courts or federal courts as well?
Yes, both of them.
Okay. At the time that you were working at Sorensen Labs, was that an accredited lab?
Yes, it was.
And what kind of accreditation did it have?
The accreditation was from ASCLD Lab, which was the main accrediting body at the time.
Okay. Now, is there anything that you had to do during your time at Sorensen Forensics to maintain your proficiency?
Yes. After initial training, there's a competency test where we show that we can adequately perform the work. And then 2 times a year after that, we perform what's called a proficiency test. So this test is administered by an outside laboratory that submits a case to us. We process it using our normal protocols. We submit the results back to that laboratory, and they inform us whether or not we got it right.
Okay. Now, are you currently the member of any forensic associations?
I'm not.
Okay. At this time, though, Your Honor, the state is going to move to recognize Mr. Cutler as an expert in DNA analysis under Idaho Rule of Evidence 702.
Any objection?
No objection.
Very well, state's request is granted.
Okay. We've heard a little bit about PCR, YSTR testing, Mr. Cutler, or PCR, STR testing. Can you tell us what YSTR testing is?
YSTR is a very similar type of testing to STR testing, except for the specific locations that are being replicated are only found on the Y chromosome. So they're metaspecific.
Why would you employ YSTR testing?
The most common use for YSTR testing is when there's a majority of female DNA within our sample that we've tested. So there's an overwhelming amount of female DNA that if we did the traditional STR test, that smaller portion would not be able to be observed.
So are you saying that you would use YSTR testing in cases where you're trying to isolate male DNA?
Correct.
Okay. Now, what kind of cases do you typically see this kind of testing done in?
The main portion is if there's a female victim with a suspected male assailant. So that can be sexual assault or any type of assault, or it's just that general type of case.
Okay. Now, why would you isolate the Y chromosome in that instance?
In that instance, the type of test where it only is replicating sections on the Y chromosome, it basically ignores the female contribution of that sample.
Okay. Now, what can you tell the jury about the Y chromosome? Is that passed from father to son?
Yes, it is. So all DNA is inherited from our parents, but the Y chromosome is basically inherited as a whole.
Now, in terms of extraction, quantitation, replication, and then comparison, other than where you're pulling the DNA from, is that process generally the same?
Yes, extraction is the same, and the process is generally the same. It is the replication process that is a little bit different.
Okay, and can you explain what you mean by that?
Yes, so in the replication process, there's very specific locations on DNA that are found to be different among different individuals. This process uses a commercial kit that we purchase, and so laboratories across the country basically use the same group of kits, and once we process it with this amplification or replication kit, it will give us a DNA profile that we can use for interpretation.
Now, if you do the YSTR testing and you arrive at a match, do you do statistical calculation?
Yes, for every match there is a calculation for statistical purposes.
Okay. Now, how does that statistical calculation differ in YSTR testing from typical PCR-STR testing?
All right, since the Y chromosome is inherited as a whole, it is anticipated that through a male line, they will have the same Y chromosome or Y STR profile. And so the statistical calculation for this is a group of individuals have donated their DNA for this purpose or allowed it to be uploaded, and there's a database created that is a random assortment of males. And so the statistical calculation is a comparison of how often that profile appears in that database versus how large the database is.
In terms of calculation, when would you say that a statistical calculation on YSTR testing is significant?
I think any match is significant, but to determine how significant, we use a method that is called a likelihood ratio. And so how much more likely is it that a DNA profile comes from a specific individual rather than a random individual chosen from the general population?
Okay. Now, when conducting YSTR testing, do you sometimes end up with DNA from different cells?
Correct.
And when we say different cells, is that different types of cells?
Correct. So a DNA extraction will give us DNA from all cells present generally.
Okay. During this kind of testing, do you sometimes isolate what's referred to as a sperm fraction and an epithelial fraction?
Right. So for specific sample types, if there's semen or sperm cells suspected to be present, there is a differential extraction which will separate sperm cells from other types of cells. They're built a little bit differently, so they're able to be isolated a little more than just a general extraction.
Okay, so you're saying you can isolate if you get a biological reference or a sample. Are you able to separate the sperm from the skin cells?
Yes, it's not a complete separation, but it generally is enough to obtain different results from the two different fractions.
Okay.
If there are sperm cells present.
Now, when you're conducting this process of separating those different cell types, or the DNA from those cell types, is there variance in the way that they separate?
Yes, there is overlap in both directions.
And what conclusions can you draw based on how the separation occurs?
Depending on the ratio of how much human DNA compared to male DNA, you can deduce or determine whether it's possible that your result is because of sperm cells. So if you have a very high ratio in the epithelial fraction and a lower ratio in the sperm cell fraction, that would be reasonable to assume that there were sperm cells present because it did lower that ratio.
Okay. Now, at the time that you were working at Sorensen Labs, did they have a protocol for reception and maintenance of evidence?
Yes, they did.
And what was that? Did you have any ways that you could identify tampering or contamination of an item when it came in?
Yes, so as soon as items are received, they're given a unique case number and outer package number and inspected just in general. Is the package sealed? They would identify different markings on the package and determine whether or not it was open upon receipt.
Now, upon receipt, so was there a document that was generated?
Yes, we call it a chain of custody document is started at the time of receipt.
Okay. And would that indicate to you as the analyst as to what kind of condition those items were in when they came to Sorensen Labs?
Yes.
Okay. And would that then be tracked in your laboratory management system?
Yes, so we have a laboratory information management system that is tracked using those barcodes, those numbers that are given upon receipt.
Okay. Now, did you receive items for testing in this case?
Yes.
Holding in my hand what's been previously marked for evidence is State's Exhibit 27. I'll ask that that be handed to the witness.
And the witness has Exhibit 27.
Mr. Cutler, do you recognize that document?
Yes, I do.
What is it?
This is a forensic evidence chain of custody that we used at Sorensen Forensics.
Okay. And did you create this document?
The document is created as the evidence is tracked through the laboratory. So as it changes from location to the individual who takes it out of the storage to do the testing and checked back into storage, and then at the end of testing, returned to our customer or client, this document shows all of those changes, or all of those changes in custody.
Okay. Does it show the condition of the item when it arrived in the custody of Sorensen Labs?
Yes, it does.
And would you refer to this item as you were conducting your testing?
Yes.
And is this item generated as a regular practice of Sorensen Labs?
Yes, it is. State
moves for admission of Exhibit 27.
Judge, I have an objection. I have an objection again under 803 6A. He hasn't testified to who made the record and whether or not that was made by somebody with knowledge. He's relying on it, so it's still hearsay. It's an out of court statement. So I would object to that.
Mr. Radford.
All 803 sub 6 requires us to do is to identify somebody as the custodian of the record. We don't have to identify the person that actually created the record. Mr. Cutler has testified that he would refer to that document in the course of his employment in testing at Sorensen Labs, and that he's familiar with the document through his employment. He's a custodian of the record, and it can be admitted.
Judge, I disagree. He's not a custodian. He hasn't testified that he has any type of supervisory powers over what's going on there. He hasn't testified that he controls what comes and goes or anything along those lines, so I don't think that they've had any testimony that he's a custodian of the record.
Anything further, Mr. Radford?
Yeah. No, Your Honor.
All right. Objections overruled. Exhibit 27 shall be admitted.
Okay. Does that identify an item that was delivered to Sorensen Lab custody?
Yes, it does.
What was that item?
So this item, it describes the outer packaging, a brown paper bag labeled number 04-P22006, item number P74453 as a ring.
Okay. And did you conduct testing on that ring?
Yes.
Okay. You can return that document to state's custody or the court's custody. And one other question about Exhibit 27. Did that document indicate whether the packaging of the ring was properly sealed or damaged when it arrived in custody?
Yes, it did.
Okay, and what did it say?
That the seal was intact, a proper seal was in place, and that it was undamaged.
Okay. Holding in my hand what's been marked for evidence of State's Exhibit 27B. I'll ask that be shown to defense counsel and handed to the witness.
Witness has Exhibit 27D.
Okay. Mr. Cutler, do you recognize that exhibit?
Yes, I do.
What is it?
It is a similar type of chain of custody document.
Is that also for an item that you conducted testing on?
Yes.
And is that document a fair and accurate representation of the chain of custody document?
Yes, it is.
Did you create that document?
I did not personally create it, but it was created at the time of the testing as each individual took custody of the evidence for testing.
Now, the circumstances we talked about with Exhibit 27, are those the same for Exhibit 27B?
Yes.
In terms of your access to the document, your use of the document during your work?
Yes. The chain of custody is reviewed at the time of writing any case report for our conclusions to make sure that everything is in place and correct for this.
State moves to admit Exhibit 27B.
Same objection under 8036, Judge.
All right, objections overruled. Exhibit 27B, as in boy, shall be admitted.
Okay. Now, looking at that document, what item came into your custody?
So this item, based off of the description, was fingernail clippings from both hands.
Okay. And was that package properly sealed?
Yes, it was.
Was it damaged?
No, it was not.
Okay. You can return that document to the court's custody. Holding in my hand what's been previously marked for evidence of State's Exhibit 27A. I'll ask that be shown to defense counsel and handed to the witness.
Witness has 27A.
Okay. Mr. Cutler, do you recognize that document?
Yes, I do.
What is it?
It's a similar type of chain of custody document.
Is that for a separate item that you did testing on?
Yes.
And the conditions that we discussed in relation to Exhibit 27, are those accurate for Exhibit 27A?
Yes.
And so you had access to this document and referenced it during the course of your testing?
Yes.
State moves for admission of Exhibit 27A.
Same objection under 8036, Judge.
Objections overruled. Exhibit 27A as an alpha is admitted.
Okay. Now, Mr. Cutler, what item does this chain of custody refer to?
This refers to a sexual assault evidence kit for Nori Jones.
Okay. And do you recall what that sex assault kit contained?
I can refer to my notes to give a full list of what was included.
Let's do it this way. Did it contain anal swabs?
Yes.
Did it contain vaginal swabs?
Yes.
Did it contain oral swabs?
Yes.
And that package, when it came into custody at Sorensen Labs, was it properly sealed?
Yes, it was.
Was it damaged?
No, it was not.
You can return that document to the court's custody. Holding in my hand what's been previously marked for evidence of State's Exhibit 27D, I'll ask that be handed to the witness after being shown to defense counsel.
And the witness has Exhibit 27D as in Delta.
Okay, Mr. Cutler, do you recognize that document?
Yes.
What is it?
It is a chain of custody document of form similar to the other ones.
Okay. And is that for another item that you did testing on?
Yes, it is.
And the conditions that we discussed relevant to Exhibit 27, are those accurate for Exhibit 27D as well?
Yes.
So you had access to this document over the course of your testing of this item?
Yes, I did.
State moves for admission of Exhibit 27D.
Same objection under 8036.
Objections overruled. Exhibit 27D is in Delta is admitted.
Okay, so Mr. Cutler, what was this item that was received by Sorensen Labs?
This item was a reference sample of buccal swabs for all that's on there says spill it.
Okay. Now, was that package properly sealed?
Yes, it was.
Was it damaged?
No, it was not.
Okay, you can return that document to the court's custody. Holding in my hand what's been previously marked for evidence of State's Exhibit 27E, I'll ask that be handed to the witness.
Witness has Exhibit 27E as an echo.
Okay, Mr. Cutler, do you recognize that document?
Yes.
What is it?
It is a chain of custody document for Sorensen Forensics.
Okay. And the conditions that we spoke about with Exhibit 27, are those all accurate for Exhibit 27E as well?
Yes.
And so does this reference an item that you did testing on?
Yes.
And was this document available to you during the course of your testing?
Yes, it was.
State moves for admission of 27E.
Same objection under 8036.
Objections overruled. 27E shall be admitted.
Now, what item does this document refer to?
This is described as a white box labeled 04-P22062, a blood sample.
Okay, does it indicate who the blood sample is for?
I would need to match it up with what is in the notes.
Okay. Do you need to refer to your
If I
notes
can
in order
refer
to
to that,
refresh your
then
recollection?
that will help me match that up.
Okay, do so now.
All right, and gentlemen, please try not to talk over one another, okay? Thank you. Sir, when you're done reviewing your notes, let the court know.
I'm done reviewing.
Thank you.
Okay.
Your next question, Mr. Radford?
Do you recall, in reference to who that blood sample was for?
Yes, this was a reference for Rio Wild.
You can return, and was that package properly sealed when it arrived?
Yes, it was.
Was it damaged?
It was not.
Okay. You can return that document to the court's custody. Now, tell me if I've got this right, but it looks to me like you received 3 references for known persons.
Correct.
And then you did analysis from those references to items of evidence that arrived in your custody?
Yes.
Now, when you did this type of testing, did you employ that YSTR testing process that we've already talked about?
Yes, for the reference samples, they underwent the same processing as the unknown samples that we tested.
Okay. So when you say that they underwent the same processing, did you extract DNA profiles from those reference samples?
Correct.
And for the items that you've already talked about, did you extract DNA profiles from those items as well?
Yes.
And all those profiles would have been Y chromosome profiles?
For the testing that we ended up doing, yes.
Okay. Now, after you concluded your testing, did you reduce your findings to any written reports?
Yes.
Holding in my hand what's been previously marked for evidence as State's Exhibit 25, I'll ask that that be handed to the witness after being shown to defense counsel.
Witness has Exhibit 25.
Do you recognize that, Mr. Cutler?
Yes, I do.
What is it?
It's a forensic case report that I authored in September of 2014.
Okay. Does that report contain your conclusions relative to the testing of these items we've discussed?
Yes, it does.
And does this report accurately reflect the analysis you conducted on the items we have previously discussed?
Yes.
Now, when you conduct testing, do you always generate a report like this?
Yes.
So is that done in the regular course of your business at Sorensen Labs?
Yes, it is.
State moves for admission of Exhibit 25.
No objection.
Exhibit 25 shall be admitted.
Okay. Let's talk about this report, Mr. Cutler. Okay, so I'm looking at item 7. What is item 7?
Item 7 is a secondary reference for Brad Compher.
And do you know what form that came in?
Based off of information we were given, it came from a cigarette butt.
Okay. Did you have the cigarette butt with you?
We received a cigarette butt, but we also received what a different laboratory has previously extracted from a cigarette butt.
Okay. And what item number was that?
The cigarette butt?
No, the DNA extract.
The extract was item 7.
Was item 7. And now, did you use that extract in your testing?
Yes.
And was that in a liquid form?
Yes, it was.
Okay. And what did you do with this item?
This item went through testing. It did not need to be extracted as it was previously extracted. So it went through a quantification step that we put all of the samples through. It will give us an accurate estimate of how much DNA is present. Then we can go through the amplification or replication process and then use that profile that is generated for comparison purposes.
Okay. So did you obtain a DNA profile from this item that was useful for comparison?
Yes.
And I just want to make sure this is a secondary reference for Brad Compher.
Yes.
Now I'm looking at item 16. What is that?
Item 16 is a reference for Rio Wild.
Okay. Did you apply that same process to this reference?
Yes.
And do you recall what form this reference was in?
This was the blood sample.
Okay. Now, from this sample, did you obtain a DNA profile that was useful for comparison?
Yes.
I'm looking at item 17 now.
Judge, I'm going to object, or if I can ask a question, an objection.
Go ahead.
When you said a DNA profile, you said that twice now for Mr. Compher and for Mr. Wild, you're referring to a YSTR DNA profile, correct?
Correct.
You're not talking about a full STR or anything like that?
Correct, a YSTR profile.
Then Judge, I think he needs to clarify that when he's talking about a profile, it's a YSTR DNA profile instead of simply or strictly a DNA profile.
Okay. Sustained.
Yeah, that's fine. Now, looking at item 17, what is that?
Reference for Robert Spillett.
Okay. Did you apply the PCR process to this item as well?
Yes.
And did you obtain a YSTR DNA profile from this item that was useful for comparison?
Yes.
Okay. Now, these items that you tested against these profiles, let's go through them one by one. I'm looking at item 1, ring. Now, did you pull a YSTR profile from the ring as well?
Yes.
Okay. And was that profile useful for comparison?
It was.
Did you then, I guess, try to match that profile against the reference samples that you had?
Yes. The results are interpreted to determine what of the results is suitable for comparison, and then after that is performed, then a comparison is done to the known references within the case. So that was done for this item.
Okay, did you find any matches from the DNA profile that was pulled off of this ring?
Yes.
And what was that match?
So this partial profile that we obtained matched the YSTR profile from Brad Compher.
Okay. Now, you mentioned that you did some statistical calculation on that. What were the statistical calculations on that match?
That it is 28 times more likely for African Americans, 11 times more likely for Caucasians, and 20 times more likely for Hispanics that this YSTR profile is derived from Brad Compher than if it were derived from a randomly selected male of that same population.
Now, in your opinion, is that a significant statistical calculation?
So as I said before, that any match can be significant, but it indicates the number of times more likely of the match coming from the individual than a random individual.
Now, from this DNA profile pulled off of this ring, the YSTR profile, were Rio Wild and Robert Spillett excluded?
Yes, a comparison was also performed to those other YSTR profiles, and they were excluded as being the source.
Okay. Now, were you able to pull a YSTR profile from the left-hand fingernail clippings?
A result was obtained, but it was not found to be suitable for comparison.
Okay. Now, what about the right-hand fingernail clippings?
From the right-hand fingernail clippings, there is a result that is suitable for comparison.
Okay. And did you match that against the references that you had?
Yes, a comparison was performed.
And did you find any matches?
Yes, there was a mixture of YSTR profiles, so more than one individual or male individual present. There was a major profile, meaning one profile had more of a signal than the other, and that major profile also matched Brad Compher.
Okay. Now, what are the probabilities for that profile?
For the statistics, 304 times more likely for African Americans, 106 times more likely for Caucasians, and 177 times more likely for Hispanics that the major profile is derived from Brad Compher than if it is derived from a randomly selected male from those populations.
I think I already know your answer, but is that, in your opinion, a significant statistical calculation?
Yes, from my opinion and the laboratories, if a statistic is reported in that, we consider that significant.
Okay. You mentioned that there was a major and a minor contributor. What conclusions, if any, can you can you make from that?
Well, for the minor portion, there's no conclusions or no comparisons can be made. It was a very small amount that we deemed that even if there was a match, it wouldn't be significant for any of statistical purposes.
Now, was Robert Spillett and Rio Wild excluded as the contributor of this DNA?
As a contributor of that major DNA profile.
Now, let's talk about the vaginal swabs. From the vaginal swabs, and that's from the sex assault kit?
Correct.
Were you able to obtain a DNA profile from that?
Yes, for this sample, it underwent that differential extraction, so the extraction that's designed to separate sperm cells from other types of cells, and that creates two different fractions. We call those epithelial fraction or skin cell fraction and sperm fraction.
Okay. Now, were you able to extract a DNA profile from the epithelial fraction?
Yes. Well, we were able to extract DNA, but no male DNA was present in the epithelial fraction.
Okay. What about from the sperm fraction?
From the sperm cell fraction, male DNA was identified, and that sample, that sperm cell fraction, was sent forward for YSTR testing.
Okay. Now, when you do the separation and you separate the DNA that you get from the sperm and the epithelial fraction, and there's no male DNA from the epithelial fraction, does that give you, does that allow you to make any conclusions as to whether sperm was present?
It is reasonable to assume that that separation is because there are sperm cells present, but there's no way to visualize or know for sure that that is where they came from.
Okay. So let's talk about that sperm fraction from the vaginal swabs. You indicated there's a minor and major contributor. Were you able to find a match for the major profile?
Yes.
And who was it?
For that major YSTR profile, it matched the YSTR profile that we obtained from the sample of Brad Compher.
Okay. Now, what are the probabilities for that?
For that one, 304 times more likely for African Americans, 106 times more likely for Caucasians, and 177 times more likely for Hispanics that the major YSTR profile is derived from Brad Compher than is if it is derived from a randomly selected male from that population.
Now, in your opinion, is that a significant statistical calculation?
Yes.
Okay. Now, are you familiar with the kind of testing that's done to detect the presence of semen?
Yes, I am.
And have you done that testing before?
I have done that testing before.
What's that called?
It's called PSA testing or prostate-specific antigen testing.
And what are you looking for in that kind of testing?
In that testing, there's a specific protein that these tests are designed to detect.
Now, is that protein more or less durable than a sperm cell?
It is less durable.
So is it accurate to say that the protein will, more often than not, break down before the sperm cell will?
Yes.
Let's talk about the anal swabs. Did you perform the same YSTR testing on this item?
Yes, the same extraction method of differential extraction was performed on this sample as with the vaginal swabs, and with a similar result of no male DNA detected in the epithelial fraction, but male DNA was detected in the sperm fraction, and that is the sample that went for YSTR testing.
And again, in your opinion, does that give you any indication as to the presence of sperm?
It is reasonable to assume that.
Okay. Now, did you compare that YSTR profile that was taken from the sperm fraction against those known references?
Yes, that comparison was performed.
And did you find a match?
Yes, that profile matched the YSTR profile from Brad Compher.
Okay. Did you find a match for Rio Wild or Robert Spillett?
Robert Spillett and Rio Wild were excluded as the source of that profile.
Now, what were the probabilities for the YSTR profile that you obtained from the anal swab?
That one is 304 times more likely for African Americans, 106 times more likely for Caucasians, and 177 times more likely for Hispanics that the profile is derived from Brad Compher than a randomly selected male from those populations.
Now, in your opinion, is that a significant statistical calculation?
Yes.
Now, let's talk about the oral swabs. Were you able to identify sperm and epithelial fraction with the oral swabs?
Yes.
And how pronounced was that separation?
For the separation, there was male DNA detected in the epithelial fraction of this sample. However, the difference in that ratio of male to total human DNA was 100 times smaller or greater, I guess, in the epithelial fraction. So that ratio was 100 times larger in the epithelial fraction than the sperm cell fraction.
Okay. Now, can you draw any conclusions as to the presence of sperm from that item?
Just that it is reasonable to assume that because there is a difference of 100 times, that it is likely that there are sperm cells present.
And was Mr. Compher excluded from that?
He was not excluded.
Now, the amount of male DNA that you were able to extract, did it meet your Sorensen Lab's threshold for continuing the testing or the comparison?
For the epithelial cell fraction, it did not. For the sperm cell fraction, it did.
Okay. But you just couldn't make any meaningful comparisons?
Right. So a result was obtained, but it was a partial result. Okay. And so with that, it was suitable for exclusionary purposes only. And so we're able to exclude, but a match would not be significant enough to give a statistical calculation.
Okay. Now, could that have been Mr. Compher's DNA?
It's possible.
Okay. Did you do any confirmatory testing in this case?
After completion of this testing, we received a buccal swab or a known reference swab for Brad Compher.
Okay, I'm holding in my hand give me one moment, Your Honor. I've lost the document. Holding in my hand what's been previously marked for evidence of States Exhibit 27C. We'll do it this way. Holding in my hand what's been previously marked for evidence as States. No, that's not it. Well, have you reviewed your notes in relation to the buccal swabs that were given to you?
Yes, I have.
Okay. And in what form were they in when they arrived at your facility?
They were in a sealed package.
Okay. Was that package damaged?
It was not.
And how did you know that it was a reference for Brad Compher?
It was labeled as such, as labeled on the packaging.
Now, did you do confirmatory testing with those buccal swabs?
Confirmatory testing with a known reference as opposed to a secondary reference, it just gets compared. It gets tested the same way as the other samples that it's going to be compared to. So in this case, YSTR testing. And then that profile is then compared to all of the YSTR profiles that are suitable for comparison in the case.
Is that a worthwhile thing to do?
Yes. So as a secondary reference is an item collected that is suspected from an individual, whereas a buccal swab or known reference comes from the individual themselves.
Holding in my hand what's been previously marked for evidence of States Exhibit 26, I'll ask that that be handed to the witness.
witness as Exhibit 26.
Okay. Mr. Cutler, do you recognize that exhibit?
Yes.
What is it?
It is a forensic case report that I authored on October 16th, 2014.
Okay. And does that report accurately describe the conclusions that you made after testing in this case?
Yes.
When I say testing, are you referring to testing the items we've already talked about with these buccal swabs that came in that were identified as belonging to Brad Compher?
Correct. So the item tested in this is just that one sample of the buccal swabs.
And as with your other reports, when you do testing like that, do you always generate a report like this?
Yes.
And is that report you're holding in your hand a true and accurate reflection of the report that you made on that date?
Yes, it is.
At this time, the state moves to admit Exhibit 26, Your Honor.
No objection.
Exhibit 26 shall be admitted.
Okay. Now, did you employ the PCR process to the buccal swabs from Brad Compher here?
Yes.
And were you able to extract a YSTR profile from those buccal swabs?
Yes, DNA was extracted and a YSTR profile obtained.
Okay. And was that profile useful for comparison?
Yes, it was.
And what did you compare it against?
This was compared against every YSTR profile that is suitable for comparison in the case. So that is from item 1, ring, and item 7, secondary reference.
So let's talk about that for a second. So why would you compare it to the secondary reference for Brad Compher?
A secondary reference is just an assumption that is a profile from an individual. And so comparing a known reference to that secondary reference indicates that it does match, and that profile that was used for the original comparison still matches the individual that is assumed to be.
And so is it accurate to say that you're doing this in order to confirm that you've got Brad Compher's YSTR profile?
Correct.
Okay. Now, did you compare it against the anal swabs?
Yes.
Vaginal swabs?
Yes.
Right-hand fingernail clippings?
Yes.
Left-hand fingernail clippings?
The left hand, I believe, did not have a suitable result for comparison. Right.
Okay. Did you get the same results for each of those items as you did in your first round of testing?
Yeah, so the comparative or statistical calculation would be the same.
Okay, and was there any variance in the results that you received?
There was not.
Now, Your Honor, at this time I'm not going to be done asking this witness questions. I'm going to ask that we take our afternoon recess. It's 3 o'clock. I've got to figure out what I did with that exhibit.
All right, a good time to take our afternoon recess. Again, ladies and gentlemen of the jury, I instruct you, you're not to discuss this case amongst yourselves nor with anybody else, or to form an opinion as to the merits of the case until after it has been submitted to you for your determination. We'll be back here at 3:20.
All rise.
No. Can I look at the exhibits?
Be seated.
Yeah, go for it.
We're back on the record. Mr. Compher with his counsel, State's counsel, all present. We are outside the presence of the jury. Concluding our afternoon recess, Mr. Radford, did you take care of that issue?
I did, Your Honor.
All right, anything we need to take up before we bring the jury in?
No.
No, Judge.
Very well. Bring the jury in, Mr. Reiner. Please be seated. We have all members of the jury returning from the afternoon recess and are seated in the jury box. Counsel, waive roll call of the jury.
Yes, Your Honor.
Yes, Judge.
Thank you. All right, Mr. Radford, you may inquire, and sir, you realize you're still under oath?
Yes.
Thank you. Go ahead, Mr. Radford.
Okay, Mr. Cutler, I just have a few more questions for you. You've testified about a number of items that you tested today, and then you testified to the reference samples that came into Sorensen Labs custody. So in terms of all the items you discussed today, can you confirm that all of those items arrived at Sorensen Labs properly sealed and undamaged?
Yes.
Was Mr. Compher
Judge, I'm going to object to that. It relies on information outside the scope of his, no personal knowledge, Judge.
I would disagree. He indicates he knows the answer to the question. He simply testified that it's accurate.
Anything further?
May I ask some questions, Judge?
Go ahead.
Mr. Cutler, you're relying on the chain of custody to know whether or not there were issues with packaging, correct?
Correct.
And so, do you remember specifically each individual package?
I rely on the document that is documented from the individuals who are trained in their job and their position to document that.
So, Judge, if he's relying on those documents which are hearsay, which is essentially hearsay, that's what I'm objecting to.
Well, they're not hearsay. They've been admitted.
No, your objection regarding the prior exhibits is standing, Mr. Fry. I understand your objection at this point. It's overruled.
Thank you.
Right, answer will stand. Go ahead, Mr. Radford.
Now, I'm holding in my hand what's been previously marked for evidence, the State's Exhibit 27C. I'll ask that be handed to the witness after it's been given to defense counsel.
The witness has 27C.
Okay, Mr. Cutler, do you recognize that?
Yes.
What is it?
This is a chain of custody form.
Okay. Is that a chain of custody in reference to an item that you did testing on?
Yes.
And all of the things that we talked about previously with Exhibit 27, do you remember that?
Yes.
Are all those conditions active or accurate for this document as well?
Yes.
Okay. State moves to admit this exhibit at this time.
Same objection under 8036, Judge.
Objection's overruled. Exhibit 27C as in Charlie is admitted.
Okay. Now, what was that item that was received by LabCorp, or by Sorensen Labs?
This is for DNA extracts that we received, so samples that were extracted from a different laboratory.
Okay. And when that package arrived at Sorensen Labs, was it properly sealed?
Yes, it was.
Was it damaged?
No, it was not.
I've got nothing else, Your Honor.
All right, thank you, Mr. Radford. Mr. Fry, you may inquire.
Thank you, Judge. All right, Mr. Cutler, I do have a number of questions for you this afternoon. I know that Mr. Radford went over the items that you tested, but I'd like to discuss them again. The first, let's see. Would it be helpful if I mentioned items that give the item number? Would you know what I mean when I say that?
Yes, without the report exhibits in front of me, I can refer to my notes or my copy if
I'm comfortable with that. All right, so item 1.0, that was listed as a ring from victim. That was the script description, correct?
Correct.
And Mr. Radford asked you whether you found the likelihood ratio statistically significant, and you didn't answer that. You don't believe that that's significantly or statistically significant, do you?
If we report a statistic, then that is considered statistically significant.
If you've testified previously before, correct?
Yes.
And you've testified specifically in this case, correct?
As a pretrial, is that what you mean?
That's what I mean, yes.
Yes.
In that you explain that statistically relevant items were if there was more than 1 in 100 for the likelihood ratio, correct?
There are different levels of statistically significant, and so for us to provide a statistic, then that is considered statistically significant. So there are different levels of strength. So there's a lower level of significance all the way up to a higher level.
Okay, that's what I'm getting to. So as far as the ring goes, the likelihood, or this ring from victim goes, the likelihood ratio that you've recorded is 1 in 28 for African Americans, right?
Correct.
1 in 11 for Caucasians.
Correct.
And 1 in 20 for Hispanics.
Correct.
So that's the low statistically relevant, correct?
On the lower end, yes.
On the lower end, right. And you can't testify that that's Brad's DNA, can you?
I cannot, where YSTR or Y chromosomes are passed on from father and son. Multiple males in the same paternal line will share the same YSTR profile.
Well, now this likelihood ratio goes back to, you mentioned there's a database of these YSTR profiles, right?
Correct.
And so you're taking the YSTR profile and saying this YSTR profile occurs this regularly in this database, correct?
Correct.
So there are other people in this database that you compare to that are going to have the exact same profile as a YSTR profile as Brad's, correct?
Correct.
So that's why you can't say that this is Brad's DNA. Is that accurate?
Correct.
Okay. Item 2.0, that is the left-hand fingernail clippings, right?
Correct.
Now, you say in there, in your conclusion, there's a minimum of 4 male contributors. Okay, right?
Correct.
When we talk about minimum of 4 male contributors, you're saying that there's at least four separate profiles there, right?
Correct.
Okay. But you couldn't conclude anything from that mixture?
Correct.
Now, on the right-hand fingernail clippings, that's also a mixture of profiles, correct?
Correct.
And there's a minimum of 2 male contributors. Is that accurate?
Yes.
So both a YSTO profile that matched the YSTO profile for Mr. Compher, and then one that you couldn't match to anything.
Correct.
All right.
Or was not suitable for comparison.
All right. And same question. You still can't say that that is Brad's DNA, right?
Correct.
Now we have item 4.0, there's rings from the victim. You had no conclusory testing on that item, right?
Right. A result was obtained, but was not suitable for comparison.
All right. So we'll skip down to item 9. Item 9 is the vaginal swab, right?
Correct.
Now you said that there's no male DNA on the epithelial fraction.
Correct.
Now you testified earlier there's a high ratio of epithelial and a low ratio of sperm, that there's probably sperm. Is that what you said earlier?
If that is what I said, that was not what it was intended. A high ratio of total human DNA versus male DNA. So if there is a high ratio, a lot of human DNA and not a lot of male DNA in epithelial fraction, and that ratio is smaller, there's a greater amount of male DNA to total human DNA in the sperm cell fraction, then that is what would be an indication.
We'll get to whether there's sperm present or not in a moment, but we'll stick with just the YSTR for now. But in the vaginal, or in the sperm fraction, you found a minimum of 2 male contributors.
Correct. So
a minimum means there could be more than 2 male contributors from that sample. Is that accurate?
Correct. So for this one, there was a single indication of a second male, but since there was so little indication for us to say specifically that there were 2 males, that is the default as a minimum of 2.
And so, again, looking at the ratio, or in comparison to you still can't say this is Brad's DNA, correct?
Correct.
For under the anal swab in the sperm fraction, we have the same likelihood ratio that we've already talked about, correct?
Correct.
And you can't say that that's Brad's DNA, can you?
Correct.
Now, every time we've talked about the YSTR profile that matches Brad's YSTR profile, we've had this likelihood ratio of the 1 in 304 African Americans, 1 in 106 Caucasians, and 1 in 177 Hispanics. You testified to that earlier, right?
Correct.
Now, item number 14. Item number 14 was a mixture of profiles, correct?
Correct.
And this was listed as, under the description, as victim's necklace, right?
Right.
And in that, there's a minimum of 3 male contributors, right?
Right.
And the YSTO profile there matches the YSTR profile for Rio Wild. Is that right?
That's right.
And Rio Wild is one of the STR profiles that you pulled from this kid. I believe it was number 16.
Correct.
Now, when we look at the likelihood ratio for this particular item, this is very different than the YSTR profile likelihood ratio for Mr. Compher.
Correct.
Is that accurate?
Yes.
In this one, the ratio is 1 in 1,878 for African Americans, right?
Right.
1 in 773 for Caucasians.
Right.
And 1 in 1,064 for Hispanics.
Right.
So this finding is far more discriminatory than the finding for the YSTR profile that matched for Mr. Compher's YSTR profile, right?
Correct.
Do you have an explanation for that?
It has to do with how many times a profile is observed in that database, and so that gives us the frequency.
Okay. The last item is item number 15, and that's a comforter, right?
Correct.
And there was a mixture of partial profiles, correct?
Correct.
All right. And with a minimum of 3 contributors, is that accurate?
Yes.
And you couldn't link those to any other YSTR profile.
Right. It's found not suitable for comparison to any known references.
Okay. So let's talk a little bit about contamination. You'd agree that contamination is a vital issue for any lab to have to deal with, right?
Yes.
And there's contamination controls that are, in essence, a lab's credibility. Would you agree with that?
Yes.
If nobody will bring samples to a lab if the lab has contamination issues, or they're not going to be able to give samples without errors. Does that sound accurate to you?
Yes, every lab does have incidences that do happen and that are tracked and available, but that is the goal of every laboratory, to provide testing without any such incidents.
And contamination essentially invalidates results. Does that sound accurate to you? Is that a fair statement?
It can.
Okay. Are you aware of the allegations against Sorensen Lab of mishandling evidence?
Objection, outside scope of direct.
Overruled. Please answer the question.
Of mishandling evidence?
Are you aware of allegations from 2019 of Sorensen Lab facing scrutiny for mishandling or contaminated evidence?
I am aware of an incident of either contamination or a switch that occurred.
And you no longer work at Sorensen Labs, correct?
Correct.
This had nothing to do with your desire to switch to another laboratory?
It did not.
Okay. If a sample were contaminated prior to your lab receiving it, would you have any way of knowing?
No.
So whatever you get is what you process, right?
Right.
Are you familiar with the term garbage in, garbage out from computer programming?
Yes.
The idea that if you bring in garbage, you're going to get garbage out, right?
Correct.
So if the sample's contaminated when it comes to you, the results are only as good as the sample is.
Right. We will get results from however a sample is when it is received.
And how a sample is collected can impact those results. Would you agree with me?
Yes.
Now, in this case, with the items that you tested or that you analyzed, were there any errors when you did any of your analysis?
There were no indications of significant errors that affected this case.
Now, if I could draw your attention, I'm going to have you look at Sorensen case number, or your report, SF010646. That's the one I'm referring to. I don't remember which of the exhibits that is.
Do you have a date of that report, Mr. Fry?
Excuse me?
Do you have a date for that report?
I didn't hear you.
Do you have a date for that report?
That report was September 5th of 2014.
I have that report.
You have that report? Now, I have questions about some of your analytics. My page numbers have been cut off, so I may have to wait for you to find where I'm looking at. Under the analyzer section of your report, it's about 2/3 of the way through. If I may approach the witness, Judge, so I can maybe help them find where I'm at.
That's fine.
John, do you want to see?
All right, are we all on the same page?
It appears so, Judge.
Go ahead, Mr. Fry.
Under that section that shows, if you turn the page over, on the left-hand side, you have item numbers 1.0, 2.0, 3.0, 4.0, 7.0. Do you see those?
Yes.
And do you see, as you go through the graph, in the middle there, it shows a reconsolidate, there's a suspected consolidation error. Do you see that?
Yes.
What does that mean?
It means that there was some inconsistency in expected results that made us suspect that we needed to reperform that test.
So you had to rework those, correct?
Correct.
And then in the next one, it shows that you needed to rework those again, correct, going down the page?
Correct.
And under items 1 and 2 and 4 and 7, those need to be reworked, it says, for suspected contamination?
Correct.
And so you had to rework those as well, right?
Yes.
And for reference, 1 is the ring from victim, correct?
Correct.
2 is the the left-hand fingernail clippings, correct?
Correct.
3 is the right-hand fingernail clippings, correct?
Correct.
And 4 are the rings from the victim. And 7 is the second reference to Brad Compher, right?
Correct.
So in those need to be worked because there was suspected contamination.
On the plate as a whole, that there was an incident observed to redo the testing for that.
All right. Let's see, we've already talked about, in your findings, you separate the likelihood ratio into 3 different ethnicities, right?
Correct.
African American, Caucasian, and Hispanic.
Correct.
In the YSTR profile, is there a way scientifically to determine whether or not that profile is Hispanic, African American, or Hispanic?
There is not.
So,
at least with the testing and comparison that we perform.
So when it talks about African American, Hispanic, and Caucasian, that has nothing to do with the sample being categorized as such, right?
Correct. This is just the frequency that is observed within those general populations that are within the United States.
How do you determine those populations then?
Those populations are self-declared from the individuals submitting their DNA for the database.
So you have this database full of YSTR profiles, right?
Correct.
And someone submits a YSTR profile, and in this submission somewhere they mark what their ethnicity is.
Correct.
Is there any way to verify whether or not that is accurate or not?
I'm not an administrator of the database, but I would assume not.
And so anyone could mark whatever they feel they want to mark on that. Is that accurate?
That's possible.
So remember I would talk about garbage in and garbage out? So that's not a very good way to base a ratio when there's not a scientific way of analyzing whether or not something is African American, Hispanic, or Caucasian, right?
What I know is this is the accepted statistical model and method used across all the laboratories in forensic DNA testing.
Now, the database you're talking about is a national database, correct?
Correct.
And so you're looking at, well, since it deals with paternity, the closer you are to where someone is from, the higher likelihood that someone is going to have a matching YSTR profile. Is that accurate?
It would depend on relatives.
So let me give you an example. 100 years ago, a person has children. As they go on, every generation, those people have children going for 100 years, right? Every 20 years, you're getting a generation. So, and they're staying in the same geographical area, right? So that geographical area is going to be a higher saturation of that YSTR profile than another area, correct?
Yes, that's a possibility.
Okay, so if we're looking at the nation as a whole, we have the likelihood ratio, but if we narrow closer to an area where Mr. Compher will be from, there could be a higher likelihood that you're going to find an individual that's going to match that YSTR profile, correct?
Correct. If there were different databases for smaller regions of the country, it may lead to different statistical results.
So if Mr. Compher is from this area and his family is from this area, there's a higher likelihood then that you'd find somebody with the same YSTR profile as Mr. Compher.
That's a possibility.
And when we talk about likelihood, well, I think we've covered that. Now, I've talked about before with some other witnesses, but it's nice to have multiple experts say the same thing. So, as far as timing goes of when a sample is deposited in a place, is there any way from the YSTR profile to know when that profile was placed on a particular sample?
There is not, with the testing that we perform.
So as far as if we make this concrete, looking at number one, the ring from victim, you have no idea based on your analysis when that YSTR profile was placed on that ring.
Correct.
Okay. All right. Now I said we would talk about the sperm fraction, so let's talk about that now. The only way to detect whether or not sperm is present is by doing a visual inspection. Is that accurate?
For confirmation, yes.
For confirmation. And there was no confirmation testing done in your YSTR profile results, correct?
Not for the presence of sperm cells.
So in the two different places, we're talking about in item number 9 and item number 10, both of those had something detected in the sperm fraction, right?
As in male DNA?
Yes.
Yes, both of those items had male DNA detected in the sperm cell fraction.
And there was no confirmatory testing to detect whether or not there was actually sperm in there?
Correct.
So you can't say with a scientific certainty that there's sperm there. Is that accurate?
Yes. I can say it's reasonable based off of the other evidence, but I cannot say for certain that that's where it came from.
And again, it needs a visual inspection, right?
To confirm the presence of sperm cells, a visual microscopy is generally used for that.
You have a process that separates the epithelial cells and the sperm cells, correct?
Correct.
And there are times where you may have epithelial cells work their way into the sperm fraction. Is that right?
Correct.
So even though you say it's how did you say, with that the other evidence would indicate there was sperm? Is that what you'd said?
Yeah, it would be reasonable to assume that that's where they came from based off of the difference in ratio between male and human DNA.
But you don't know whether we could have a situation here where in the separation an epithelial cell had made its way into the sperm fraction versus the epithelial fraction.
Correct. It would be unlikely to have all of the male DNA make it to the sperm cell fraction and none of the male DNA make it into the epithelial fraction if it was not from sperm. So it's possible, though it would indicate that it is not likely.
Is there a way to specifically verify that?
There's not.
Aside from visual confirmation?
Correct.
And in a case as important as this, wouldn't you think that doing a visual comparison would be the appropriate method?
We were not directed to attempt to see which types of cells were present, just to generate DNA profiles.
And you don't have any control over that. They hire you, you do what you're told. Does that sound right?
Basically.
Basically, okay. I don't have any other questions, Judge.
Thank you, Mr. Fry. Mr. Radford, redirect.
Okay, Mr. Cutler, these allegations in 2019, that would have been 5 years after you did the analysis in this case?
Correct.
Okay, and are you familiar, were those allegations in 2019 resolved?
In my opinion, yes.
Okay, and did they remain merely allegations?
There was an extensive investigation on our part. We used a lot of resources and time to investigate it. We took the allegation seriously and went through every case that we had performed during the time in question. A specific process was identified, which was used after the processing of this case. And we went through all of those cases, identified specific cases that we were not able to confirm based off of other samples within the test. We indicated which samples we could not confirm and suggested additional testing. And we also changed our process significantly to attempt to prevent any such incident to happen again. But the numbers that were involved in that almost 60,000 samples went through the laboratory during that time. We identified 3 issues and an additional 5 that we suggested additional rework on just because we could not confirm those results. So in terms of a percentage, every lab does not want any incidents, but in terms of percentage, I would say that that's a low percentage of 8 out of 60,000, but we did take that seriously and we made significant changes.
Now, did anything like that occur in your analysis in this case?
Not in this case, and none of the incidents had to do with any of the cases that I authored.
Okay. And if something had happened in this case and you discovered that for some reason the results that you arrived at were not reliable, what would you do in that situation?
First attempt would be to remediate and fix any issues, as was done in the issue where there was suspected contamination, or the test was reperformed and the indications that were observed to begin with were no longer present, and we concluded that that was significant and that the results were reliable.
Okay, Mr. Fry asked you a series of questions about having to redo some work on this, a suspected consolidation. When you redo the work, do you basically redo it until you get a reliable conclusion?
As much as possible.
And can that be caused by, say, something like blood on the items or polish on the nails, something like that?
Generally, it's due to instrumentation, or there could be a small isolated incidents of contamination. When it's observed in the controls, then the test is redone to confirm that contamination, and in this case, it was no longer present, and results were found to be reliable.
Okay, so the fact that you had this event occur on some of these items, does that impact your conclusions or your opinions that you're testifying to today?
It's taken into account, and so the whole process, making sure the results are reliable before we report that out is taken into account in the analysis.
Okay. Now, Mr. Fry asked you some questions about the statistical calculations in reference to the necklace that returned to, I believe it was Rio Wild. Now, is it accurate to say that statistical calculations you're dealing with here, the reason they are the way that they are is because you're specifically dealing with that Y chromosome?
Correct.
And that's shared from father to son and brother to brother?
Correct.
Okay. Now, if the statistical calculations with Mr. Wild are greater than they would be for Mr. Compher, does that just mean to say that Mr. Wild has fewer people in his paternal line?
Possible is just a matter of the database, which samples are in the database. The assumption is made that it's a representative number of individuals, but as we pointed out, it is a national database.
Okay. But really, when you're doing this kind of analysis, you're doing this kind of testing, you're looking at locations along that YSTR line. Is that accurate?
YSTR chromosome, yes.
Okay, and what locations, how many locations are you looking at?
For the specific commercial amplification kit that we use, there's 23.
And did you look at those locations in this case?
Yes.
Now, in looking at those locations, let's disregard simply when you're looking at those locations, in relation to the ring, looking at the 23 locations that were extracted from the ring, did those match the 23 locations from the DNA profiles from the references for Brad Compher?
For the ones that were complete profiles, yes.
Okay. And that's the secondary reference and also the buccal swabs?
Correct.
Now, is it the same thing for the right-hand fingernail clippings?
That one, I believe, was a partial result.
Okay. But is it accurate to say that if you extracted the YSTR profile from the right-hand fingernail clippings, you ended up with at least some of those locations?
Correct. There is a minimum number of these locations that is necessary in order for us to qualify that as suitable for comparison.
Okay. And you were able to look at that minimum number of locations and compare that to the known reference and the secondary reference for Brad Compher, correct?
Correct.
And at those locations, it was a match?
Yes.
What about the anal swabs?
Yes.
And the vaginal swabs?
Yes.
I've got nothing else.
Judge, I have more questions based on that.
All right, you may proceed.
Mr. Cutler, you mentioned that you changed your process significantly after the allegations of the mishandling of evidence, correct?
I'm not aware that it was about mishandling of evidence, but yes, the allegation of what we were discussing.
And so this situation that we're talking about happened in 2019, does that sound right to you?
Somewhere around there, yes.
So from 2014 to 2019, did you still have the same processes in place?
The process that it was identified as an issue started in 2016, I believe, so after this testing.
Now, we're talking about samples of a database, samples in a database where we're comparing a likelihood ratio, correct?
Correct.
So if we change the number of people in the database, that's going to impact what the likelihood ratio is. Does that sound right?
Yes, if the number of profiles going into the database differ from what is already in there, then that can cause a change.
Is that database static?
Yes, there are profiles being added to the databases as time goes on.
So let me back up. When I say static, I mean the number of profiles in the database increases.
Yes.
Is that what you're saying?
Yes.
So it's dynamic in that it's from 2014, that database is different than what that database is today.
Yes.
So depending on when you run the numbers may depend on what that likelihood, what year you run the numbers may impact what that likelihood ratio is going to be.
It's possible.
Okay.
It's expected that it's not going to change dramatically, but it is possible to have some changes.
So if you ran these numbers today, you may have a different result. That sound right?
It is possible.
Okay. Are you aware that the allegations regarding the issues with Sorensen Lab went back as far as 2008?
I'm not aware of that, but that is when the laboratory first began.
In 2008?
Correct.
Okay. I don't have any other questions, Judge.
Thank you. Anything further, Mr. Radford?
Nothing, Your Honor.
May this witness be excused.
He may, and he's released from the state subpoena.
Yes, Judge, you can be released.
All right, sir, I'll let you be excused at this time. I just need to admonish you, you're not to discuss your testimony with any other witnesses in this matter. Thank you, sir.
Your Honor, we're at a point in the case where, okay.
Okay.
Your Honor, at this time, I would ask to admit State's exhibit, proposed exhibit right now, number 3. It's a petition in order for a name change from the defendant, changing his name from Ralph Roy Compher to Brad Scott Compher in 2008. This has been certified. I can provide a copy to Mr. Andrew to look at.
Your Honor, I've seen the exhibit. I concede it's self-authenticating.
All right, no objection then, Mr. Andrew?
No, Your Honor.
All right, State's Exhibit 3 shall be admitted.
I'll ask the court to take custody of this exhibit.
We shall.
Can we approach, Your Honor?
Yes, you may. All right, ladies and gentlemen of the jury, we're going to recess at this time. I'll let you go a little early today. So again, during the recess, you are instructed not to discuss this case amongst yourselves, nor with anybody else, nor to form an opinion as to the merits of the case until after it has been submitted to you for your determination. Have you back here by 8:45 tomorrow morning in the jury room, and we'll start at 9 o'clock. All right, enjoy your evening.
All rise.
Please be seated. Okay, we're on the record outside the presence of the jury with attorneys and for both parties present, Mr. Compher present as well. So I wanted to take up the issue of Mr. Radford, your contact with juror number 1, and then Mr. Andrew, the other day, your contact with juror number 11, I believe. So I think what I want to do is bring them in one by one to confirm that the conversations were nothing that would require any mistrial. So, Mr. Andrew?
Just to simply state what occurred on the record and have the jurors then have these.
Yes. All right. Paul, would you bring in juror number 1, please?
Just do it from there.
Well, in maybe one of the front row seats, so we can hear okay. All right, juror number one, thank you for staying for a minute. There's some matters we need to take up with you. You're not in trouble, okay? So I'll tell you that, all right? So we're not trying to single you out and say you're in trouble for anything. So, Mr. Radford, do you want to state for the record what occurred?
Well, Your Honor, I have a habit of greeting people as I walk up the stairwell. I was walking up the stairwell. Juror number one was coming down. Before I realized it was juror number one, I said something like, hi. She said hello. And I said, oh, and that was the end of the conversation.
Okay. You just said oh?
Oh,
okay.
Like we're not supposed to talk to each other kind of
okay.
thing.
Okay, nothing followed the O. All right.
Correct.
Okay, so juror number one, was that the extent of your conversation with Mr. Radford today?
All true and exactly how it happened.
Okay. And there was nothing else said between you and Mr. Radford?
No, just like American hello utterances when you know somebody's near you and then you realize who it is. And, yeah.
All right.
We even looked at each other, I think.
Okay. Mr. Andrew, any questions you want to ask?
No, Your Honor.
All right. Thank you, juror number one. You're excused. Have a good evening. Yeah, bring in number 11, please. Juror number 11, we brought you in here to ask you a few things. I understand you had some contact with Mr. Andrew the other day. So we'll have Mr. Andrew state what the contact was, and we'll go from there.
Your Honor, I was coming to the courthouse for court in the morning, and he was walking kind of in the direction of the DMV, looked over his shoulder and asked if court was at 10:45. I didn't recognize him at the moment, and I know that court starts at 8:30 generally, and just said it started at 8:30. Then realized who he was and just continued to walk into the courthouse. I know he walked in before me. I stayed several paces behind him, let him go through before I went in, so that was it.
All right, so juror number 11, is that the extent of the conversation you had with Mr. Andrew? Yeah, nothing else was said between you and Mr. Andrew? All right. Mr. Radford or Mr. Trammell, you want to ask any questions?
No, Your Honor, I saw that interaction, and it's, as they say, it is.
Okay. All right, so juror number 11, just remember we can't have you talking to the attorneys, okay? All right, you're not in trouble, everything's good. All right, thank you, juror number 11, have a good evening. Okay, we are back on the record outside the presence of all jurors. Attorneys are present for both parties, and Mr. Compher is present. So tomorrow, Mr. Andrew, you're indicating calling Mr. Spillett. He's subpoenaed for tomorrow.
Correct.
We've tried to make contact with Mr. Eldridge to notify him of that. Everything's taken care of.
During the lunch hour, lunch break, we were able to sit down with Mr. Eldridge, explain to him the evidence that I was providing to him on a disc, so that he could kind of come up to speed quickly, and kind of procedurally that we were going to try and start at 9 o'clock, and so we're really interested in whether or not Mr. Spillett was going to assert a Fifth Amendment privilege to some or all of whatever we were going to ask. So.
Okay. All right, good. I'm glad we got that resolved, at least on the issue of Mr. Eldridge and Mr. Spillett being notified.
And, Your Honor, I also put the information I had on Mr. Adamczyk on a disc for Craig Parrish, and he's been notified that that's available as well, which is a copy of interviews and police reports. So
okay.
We'll have to come up to speed.
All right, I appreciate that as well. So.
And I do have 2 items before we recess, Your Honor.
Okay. Well, before we get to those, then, Mr. Andrew, your list of witnesses or expected witnesses for tomorrow?
going to take a second here. Would be it would be Robert Spillett, Ralph Daniels, Detective Brennan, Detective Collins.
You said Collins?
Collins, correct. Collins. And I'm going to give you the witnesses I intend to call, but it kind of depends on how the rest of the how tomorrow goes. I would like to call Detective Stone, Tom Sellers, Kevin Coffin, Officer Howe, and then there will be Mr. Adamczyk, Mr. Draper. With regard to, hold on a second. Your Honor, I submitted a motion on this afternoon on Stephen Roberts. He's the person we've been trying to track down in Arizona, and we're able to find out today he's actually in the custody of the Idaho Department of Corrections. So I've submitted a motion to have him transported over, and the proposed order says just to have him available to testify on the 1st at 9 o'clock. There is the possibility that I would call Doug Coffin, but we haven't made a decision on that yet. I think Mr. Proctor wants to talk to him again before we make a decision on that. I think that is the entirety of our witnesses, and I think just depending on how things flow, I think we're telling people to be ready to go at 9. Given our procedures, kind of focused on Mr. Spillett tomorrow, Mr. Adamczyk on Friday. And then a lot of these witnesses, like Detective Stone, are kind of, can also be sort of fillers. So Mr. Coffin is kind of a filler.
Thank you, Mr. Andrew. Okay, any other issues you had then?
Just one, Your Honor. Mr. Proctor was going through stuff today. There was a particular exhibit he noted, and then he asked me what exhibit number we had for it, and I couldn't find it in our list of exhibits. We did get it in Discovery. It's just a Pocatello inventory sheet that was prepared by Detective Stone. I think that's another one where I had assumed it was on the discs and it got labeled, and in fact it was on a thumb drive that we had. So it was provided in Discovery, and I will submit a supplemental exhibit list, and we're calling it LLLL, so 5 L's, and we've provided a copy of it to the state. Our intent is to ask Detective Stone about that.
And you want that admitted as an exhibit potentially?
Yes.
Okay.
So I'm letting you know that it wasn't on our exhibit list. We did get it in Discovery, and so we're providing it at this point.
Okay. All right, well, we can let the state review that, and if there are any issues, when you call Detective Stone up to the stand, we'll take it up then.
Gary? That's all we have, Your Honor.
All right, anything else from the state before we recess for the evening?
No, Your Honor.
Okay, thank you all. Enjoy your evening. We'll be in recess.
All rise for the